Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Courtroom buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes and shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines of right blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Families watch, soul torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence, justice seeks. Around the world, eyes through gaze. Every trial a twisted maze. Judgment passed through smoky gates. In this court, no room for haste.
Hello, good morning, everybody. Good morning. It is Friday. It's starting of the last day of the week. Yes, it is afternoon here. It is 2 p.m. right now, and it is very hot. It is right about the temperature that I said it was going to be. It's about 86 degrees, I think. So it is very warm. I'm not going outside no more. I'm inside for the rest of the day, and no one is going to take me out of here. I thought of like there's a couple possibilities we could do today. But first of all, good morning, Cindy. Sam. Thank you very much, Samantha, for coming by and just dropping a like. But yeah, so there's a couple bits we can do today because there is no trial until Monday. And good morning, Denise. I hope you were okay and happy Friday. What we could do is there's several possibilities because I was thinking of doing like a shortish day today because obviously our court is not here. It is Friday. Um, and I want to chill as well and spend some more time with Garden. But yes, I haven't had enough time to with Garden, but I need to spend more time with him. But good morning. Yes, exactly. Summer starts today. It's summer day. Good morning, Stephanie. Good morning, William. Hello. Um Denise, that is not good. That is not good. I would talk to your bosses about that because that is not good. And I hope that is not too hot over there in Idaho. I had a plan for the day, right? I really want to talk about the Idaho Red Rums, the Brian Koberger case, and I want to do a deep dive. But I chickened out for some reason. I chickened out, and now I'm not ready for it. Maybe another day we can do a deep dive on that case because I really want to do it. But for some reason, I got very insecure, and I just didn't do it, and just decided not doing it for some reason. But uh, what we can do is we have several possibilities. I found some videos. I found I think I think it is the original arraignment of Karen Reed, and then when she pled not guilty of the Red Rum of John O'Keefe. We could rewatch that. That would be fun. Like after now knowing the outcome, and I did find like one day, literally one day trial, a 6 hour trial, which we can watch sped up. That would be probably a day if we would watch that one trial. Or we could just go to Miami and do some court hopping because courts are actually starting again today. Because I was a bit afraid that the courts were not going to come on, and we would be left like without doing anything, and it would be just me talking all day. And guys, I don't like to talk too much because it's me after all. But I am not on camera today because, and I'll tell you why before court starts, because court is already
Hi, everybody. Good
starting.
morning and welcome to Felony First Appearance Hearings. I am Judge Mindy Glazer. I will be presiding today. The video for first appearance hearings has been played to all defendants. I need everybody Please stand up, raise your right hand, and be sworn in by our clerk.
Buenos días a todos, la juez Mindy Glazer, en esta audiencia del día de hoy de primera comparecencia. Todo el mundo de pie, levante su mano derecha para ser juramentado.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
Jura, afirma el testimonio que ahora la verdad y nada más que la verdad. Responde en voz alta, sí.
Thank you. Please be seated.
Gracias, por favor, tomen asiento.
Have a seat.
Tomen asiento, tomen asiento.
Raise your right hand and be sworn.
Do you swear that you will well and faithfully interpret from English to Spanish, Spanish to English, the questions asked and the answers given to the best of your ability, and that you have such ability?
I do, for the record, Juan Morin, Senior, Certified Spanish Court Interpreter.
Good morning. If there
Good
is
morning, Your Honor.
a case on Zoom, please type the defendant's name in the chat room.
Si hay alguien que tiene un caso en Zoom que quiere escuchar, pongan el nombre del acusado en el chat.
Well, I'll promote the attorneys after when I'm on their case when we start the felony calendar. As you can see there, go ahead.
From there, that's where you guys wanted me to be on, right?
Let's get started. Attorneys, can you please announce for the record, state?
Good morning, Anna Romas on behalf of the state for out-of-state expeditions.
Isaac Whitfield for everything else.
Good morning.
Good morning, Your Honor. Assistant Public Defender Jessica Vaquero Rodriguez.
Good morning. All right, so we're starting with the out-of-state warrants. We have Quentin Hodo. Mr. Hodo here.
Yeah, no.
How are you, sir? Metro West 4. It looks like we need a little bit more time to pick you up. They need a 2-day extension from Georgia. I'm sorry about the delay, but they're entitled to it. So I'm going to grant the extension, reset it. Instead of the 27th, they're going to pick you up by June 30th.
They're going to pick the last, are you?
No, they're going to, instead of the 25th, they're going to pick you up by the 27th. We're going to reset the case June 30th to make sure you're picked up. Okay? I'm sorry about the delay, but at least it's only 2 days instead of 15. Have a nice day, sir. All right, next we have is Lloyd Francois Quash, Avery Bass Quash, new case from William Miranda. No locals is a good thing. Come on down, Mr. Miranda. Is he here? Corrections, is Mr. Miranda present?
Corrections asked for 1 moment.
1 moment, Your Honor. I'm so sorry. So sorry.
Judge, very briefly, while we're waiting, either this week or last week, there was a 17-year-old with a fugitive warrant out of Louisiana. I was wondering if we would be able to address that today. We do have more information about the alleged warrant.
I'm not touching that one. I already ruled on it. I mean, tell me what the issue is, but they were coming to get him.
Judge, as far as our office did get in contact with the family and the private attorney assigned to that case. And the private attorney provided us the only warrant that was ever issued for client, and that warrant was already quashed back in March.
That's not what, Ms. Romas, are you there?
That's not the information I received, and that's not the information that's being channeled through. It's true that in March, the family was supposed to present itself and bring Mr. Jackson into the police, and it says that in the warrant, but they didn't appear. And
well, Judge, I have a signed order from a judge saying that it quashed the warrant.
The date of that warrant, that signed order.
That order has not been shared with me, Your Honor.
I can go ahead and forward that to Your Honor and the state.
No, forward it to Ms. Romas, not to me. Forward it to Ms. Romas, and if she'll look into it, and if he needs to be released, do it.
I'll look into it, Your Honor, but the information we received is Louisiana is coming to get him, and he should not be released.
And they're expediting their pickup because they want him.
What is the email, Your Honor?
It's ANAROMES@miamisao.com.
So, Ms. Romas, if you look into it and you find that they are correct, I'm sure you will instruct the deputy to release him this weekend.
Absolutely.
Any other issues on this? I'm happy to readdress it on Monday, okay?
I'll contact Louisiana. I'm going to do it.
Yeah, Ms. Romas, you'll forward it to The deputy,
Yes, once I receive the purported order, I'll report it to Detective Toyos and I'll reach out again to Louisiana.
thank you. All right, now we have William Miranda. Come on down, sir.
Yes.
Hi, Mr. Miranda. Do you speak English?
Habla inglés, señor Miranda.
No.
Oh,
Sir, you were arrested on a
No.
warrant from the state of Georgia.
Usted fue arrestado por una orden de arresto del estado de Georgia.
The charge is for felony, probation violation.
El cargo es por un quebrante de una probatoria, un delito mayor.
The warrant was issued November 14th of 2024.
Esa orden fue dada en noviembre 14 del 2024.
No bond on this arrest warrant.
No hay fianza en esta orden de arresto.
You can either agree to waive extradition and to be transported to Georgia. They'd have up to 30 days to pick you up.
Tiene o que renunciar la extradición y entonces el estado de Georgia tendría hasta 30 días para recogerlo.
Or you can contest extradition and fight the warrant, and then you'll be in our jail at least 90 days so that you can fight the warrant.
O puede pelear esa orden de arresto y estuviese en nuestra cárcel hasta 90 días para que usted pueda pelear esa orden de arresto.
Either way, it's no bond. What do you want to do? Waive extradition, agree to go to Georgia, or contest extradition and fight the warrant?
De todas formas, no hay fianza. ¿Qué es lo que quiere hacer? ¿Renunciar a la extradición para que lo lleven al estado de Georgia o pelear la extradición?
No, yo quiero pelear la extradición. Eso está mal.
I want to fight extradition because that's wrong.
No problem. You're going to have a pre-signed waiver that the state's going to have to provide to the court, and I'll treat it as a contest.
Muy bien, no hay problema. Va a tener un formulario que ya prefirmó que se lo proveen al tribunal y eso lo voy a tomar como una disputa.
All right, contest, appoint the public defender's office. It's no bond, and reset it in 30 days. Go get me the pre-signed waiver.
Muy bien, va a pelear la extradición, lo van a retirar en 30 días a ver lo que va ocurriendo y la juez pide que le den ese formulario firmado.
Reset July 21st, and we'll bring you back in sooner. If we get that pre-signed waiver, you're going to wind up going anyway.
Ok, julio 21 y se lo traemos de vuelta antes y cuando recibimos esa renuncia ya firmada.
Next, we have Brian Andrews. New case, no locals. Line them up, bring them in. I have a big calendar today. The PD knows to waive, you can waive defendants' presences on certain cases where they're in custody
Yes, Your Honor.
by a detainee and all that. Apparently, they've reset a lot from yesterday.
Mr. Andrews? Go ahead.
Good afternoon. Good morning, Mr. Andrews. How you doing? Sir, you have an arrest warrant from Maryland. It was issued March 7th of 2025 for a felony false card charge for goods. So it's some type of a theft card charge. There's no bond on the warrant, and I need you to tell me if you want to waive extradition or contest extradition. A waiver is the quickest way out of this jail. Maryland would have up to 30 days to pick you up. If they don't get you within 30 days, you get released. The other choice is to contest extradition, which means you want to fight the warrant. You're not fighting the charge. You're not fighting the charges, just a piece of paper that says you are wanted in Maryland. A lawyer would be appointed for you if you couldn't afford one, and you'd be able to challenge the legal sufficiency of a governor's warrant. That being said, I know you got arrested at the airport. You live in Maryland. If you waive, it's the quickest way out. That's what most people do. Hopefully, they'll get you within 15 days. They can't hold you more than 30 days. You want to waive?
Yeah, because
You sound like a little ambivalent. You got an arrest warrant. It's no bond on it. If you waive, they have up to 30 days to get you. If you contest, it's 90 days. Do you want to waive or contest?
yeah, I want to waive it.
Smart choice. You get out of here quicker.
One thing,
15 days. What?
one thing at the airport, they took all of my my license. They have my
Action, get released. They put it in your property, I guess, the property there.
they
So-
put it in the at the airport in the storage along with my luggage and everything else. They took everything. I only have my passport here.
Deputy,
I don't know.
you'd have to,
CBP, the ones that.
Customs Border and Patrol.
Yeah,
You'd have to
customs has
fire-
everything.
I don't know what happens, and we don't have our regular PD today. Need somebody at the jail can tell you how they handle it. Otherwise, you can check at the police department, at the airport. It's a waiver, no bond, reset July 7th. So that's to make sure you've been picked up and transported. And let me see what else. Make sure to sign the waiver paperwork at the jail. It just means you agree to be transported over to, back to Maryland. All right, so they're probably gonna just get your stuff when they take you home.
Okay.
All right,
Yeah, because I wasn't even here when I got mine.
good luck. Have a good day. Letitia Mopkins next. And
Your Honor, excuse me, sorry, apologies for interrupting. If we could take up Mr. Jackson for just one brief moment, since he has a lot of family typing a lot of things into the chat. I have some information. I just received the order from Ms. Viquera.
Okay.
The quash order was signed on March 27th, and the warrant we have issued and the warrant on which they're going to pick up Mr. Jackson was signed on April 15th after whatever was quashed. So the warrant we have is a valid warrant in effect.
So there's a second warrant that was issued in April. It's not in March, so that's why he's being detained. Talk to the lawyer. And what state is it from?
Louisiana.
Back to the lawyer. There's a second warrant, April what, 18th?
April 15th.
April 15th. So go back and talk to the lawyer and let them know that, and they can go see a judge there. I'm here on Monday if there's any new developments, okay? All right, next, Ms. Mopkins, good morning. You have an arrest warrant from Illinois. I'm sorry, you have an arrest warrant from Maryland for theft. There's no bond on the warrant. The warrant was issued April 2nd of 2024. I need you to tell me if you want to waive extradition or contest extradition.
Waive it.
Waiver is the quickest way out of this jail. Has up to 30 days to come and pick you up. If they don't pick you up within 30 days, you get released. I try and get you out of here quicker in 15 days. The other choice is to contest extradition. It means you want to fight the warrant. You're not fighting the charges. Just a piece of paper that says you wanted in Maryland, and then a lawyer will be appointed for you if you cannot afford one. Your lawyer will be able to challenge the legal sufficiency of a governor's warrant, but you'll be in our jail at least 90 days. So do you know what you want to do? Do you want to waive or contest?
Waive it.
Smart.
Waive it.
You get out of here quicker. Please make sure to sign the waiver paperwork at the jail. The reset date is July 7th. Have a good day, ma'am.
All right, thank you.
Thank you. Next is Princess Ellis. Now I'm told, hello, ma'am. She has local set today. What she contested is now, does she want to waive? Is that why she's here? Are you here because you now want to waive extradition?
Correct.
Okay. So now we'll treat it as a waiver. There's no bond. It's reset. She has local set today. You want me to set it Monday, see what's going on with the locals?
F25-11056. It says no, I'm sorry, that's for us. I apologize. She had, I'm so sorry. Doesn't have a date. I'm sorry.
We'll just reset it Monday to see what's going on. She may go Monday if she's here today. Set it Tuesday, June 24th, to see what's going on with the local cases. Please make sure you sign the waiver paperwork at the jail. It just means you agree to be transported over to Georgia. Next is Monet Ward. I'm seeking extension. Is Miss Ward there?
Yes, Judge, she's here.
But Georgia, they're slow today. Hi, Miss Ward. I'm so sorry, but Georgia needs an extension of time to pick you up. I think that's what it is. So they need 10 days from Georgia? Or is it Missouri?
Missouri, not Georgia.
It's Missouri. Yeah, Georgia's not. I'm sorry, they need an extension of time of 10 days to pick you up. So they're going to come anytime between now and July 11th. I'm really sorry about the delay. That's not 10. Oh, they're going to pick her up on the 1st?
Right, the original time.
Your Honor, they already put a pickup time.
They got a pickup date. So they did that, but you shouldn't have to wait that long, ma'am. According to corrections, you'll be going sooner. So we're going to read
the first.
They instead of the 1st, they're saying July 11th, but they're going to come anytime between then. And according to corrections, it sounds like it's sooner rather than later. But I'm resetting the case July 14th to make sure you get picked up.
Oh,
Good luck to you, ma'am. I'm sorry about the delay.
thank you.
Next is Daniel Egerton. Mr. Egerton here? Is he here? Is he?
Could be Metro West.
I don't see him there. What's going on? It's a reset.
And I'm sorry, Your Honor. If there's any way I could get that new warrant for Mr. Jackson or a copy of it.
Have a copy of the warrant?
No, I do not have authority to release the copy of a warrant.
The lawyer can get it and let him go to, I think they release it once it's been issued, once the defendant returns to the state. It may be a warrant. All right, June 20th of 2025, that's today. We have locals for Mr. Egerton.
Your Honor,
Yes.
Mr. Everton refused. My apologies.
Reset June 25th. I'm sorry. Reset 625 locals. All right, so we'll see him next week. Raciel Ochoa Acosta is a quash. Latrell Belfon is a quash. We have John Thornburg. He's at Metro West 8. Good morning.
I'm sorry, Your Honor, for Mr. Ochoa Acosta. The person that does, I'm sorry, because I don't know what the person that does the warrant, did they send a quash? Because I don't have one attached on here.
Have demanding state withdrew or abandoned.
I don't have the withdraw.
They said they sent something.
I don't have it. Is there any way possible if they could please send it again?
Can you resend that again, please, to corrections?
Because I have nothing attached. I'm sorry. Thank you.
Good. All right, now we have, who's this?
No, I'm sorry, Your Honor. This is the one that was at 30 days. So
I don't-
that's not relief because what happened is it didn't come.
They didn't come pick them up, so they didn't pick them up. We're releasing them.
Correct.
But
Okay, so it's not a quash then.
if we did a quash motion this morning.
It's a quash.
We watched it because it didn't.
They've abandoned their request for him to be extradited. It's a quash.
Okay, so then would they be able to, are they gonna send something over or do I need?
How does he
He's
get?
gonna go for immigration, so he's going to immigration.
That's fine. Maybe they want that, but he's ready to go to immigration then.
I just need to know if warrant is gonna send something. If not, then I need to find out what I gotta do.
All right, thank you. Next, Mr. Thornburg, good morning.
Good morning.
So you have, your locals are closed. That's great. We can start the extradition process for Georgia to pick you up. We're going to reset your case July 7th to make sure you get picked up. Just don't pick up any new law violations. That's the only thing that would delay you.
Right.
And I said July 7th. Next case is Patrick Palmer.
Your Honor, he's not gonna be, NBC.
Thank you. Traffic case is closed. Is he ready to go or is another, what, that's the child support?
No, he's ready to go, Your Honor, so we could set a date.
Great.
They quashed the.
Child support warrant.
Yeah.
July 7th to make sure he gets picked up. Okay, Deputy? For Patrick Palmer, July 7th. Then we have Sean Brown. Mr. Brown here. Locals are pending. I don't know where Mr. Brown is. I don't know how these. For Mr. Brown, I'm resetting it July 8th, the day after it's locals. All right, that's it for the out-of-state warrants. Thank you, Ms. Romas.
Thank you, Your Honor.
All right, next is in-state calendar, Sierra Bass.
It's back, Sierra. Come on, man.
Good morning, Ms. Bash. You have an arrest warrant. It is from Broward County. The warrant was issued June 18th of 2025. It's a not in custody capias for aggravated battery with a deadly weapon, burglary to an occupied dwelling, and aggravated assault with a deadly weapon. There's no bond on this warrant. Broward's going to have up to 15 days to pick you up. I'm going to reset your case for June 7th to make sure you get picked up. And if you have any questions, you can call the public defender's office. All right. And unfortunately, it's no bond, but Broward usually comes once a week. You shouldn't have to wait that long. The reset date is July 7th. Have a good day.
And Your Honor, sorry, just to be clear, that was July 7th.
July 7th, 15 days, but Broward comes once a week. Once you get to Broward, there'll be a bond, we hope. All right.
Thank you, Your Honor.
Bond when I get the bond.
Don Manderson is
No
next.
set a bond. Okay. You're good to go, though.
Ms. Manderson, you have an arrest warrant for Broward County that was issued February 5th of 2025. The charge is petty theft, and there's a bond of $100. I will appoint the public defender's office for you. If you can post a $100 bond, please do so at the jail you're located at. If you do not have any money for a bond, you will have to wait up to 15 days for Broward County to pick you up. Your case is reset here July 7th to make sure you are transported or bonded out. Have a good day.
Thank you, sir.
Next we have is Steve Sannon.
Come on, Sandra. Go, go, go.
Good morning, Mr. Sannon. You have an arrest warrant from Broward County. The warrant was issued June 18th of 2025. It says not in custody capias for grand theft. I will appoint the public defender's office for you. I don't know. Do you have any money for a bond? Sir?
Ma'am. Yes, Your Honor.
I don't know. Broward may agree to a bond. They may not. I don't know if the PD wants to look into it and I can reset it in the afternoon.
Yes, Judge, I'll look into it.
Okay. So. All right. Reset him for the afternoon. Next, we have Eduardo Valero. Good morning, Mr. Valero. You have a warrant from Hillsborough County that was issued on February 3rd of 2025. You owe child support and it's $1,500 cash. So you'd have to pay $1,500 cash at the jail you're located at. If you don't have any money for a bond to pay that cash purge, you will have to wait up to 15 days for Hillsborough County to pick you up. Your case is reset here July 7th to make sure you either posted that cash purge or you were transported to Hillsborough County. All right. Have a good day. Next is Paul Strasburger. He's on Zoom, Metro West 2. Good morning, sir. You have a warrant from Sarasota County, Florida for violation of probation. The warrant was issued January 9th of 2025. There is no bond on the warrant. The public defender's office is appointed and Sarasota County has up to 15 days to come pick you up. Your case is reset here on July 7th to make sure you are transported. Have a good day.
My case is closed, but thank you.
I have a warrant from there. It says
Yeah.
violation of probation, so it's still open. I'm sorry.
Okay. I appreciate you. Thank you.
Roger Picot, he's at Metro West 3. Good morning, sir. You have
Yeah.
a warrant from Broward County that was issued December 5th of 2024 for violation of probation. Unfortunately, there's no bond and you'll have to wait up to 15 days for Broward County to pick you up. Your case is reset here July 7th to make sure you are transported. Broward usually comes once a week. You shouldn't have to wait that long.
Yes, ma'am. Thank you.
Thank you, sir.
Yes.
Kiran Mazira, Metro West 5. Good morning.
Yes, ma'am. Good morning, ma'am.
You have, it says, what is this, a hold for agency, immigration? Is it reduced to, no, it's a hold for Palm Beach County for violation of probation. So we have to get that warrant, the hold needs to be reduced to a warrant.
And Your Honor, he also has an immigration hold.
You want me to set it next week, Tuesday, to see where that warrant is? Let's set it the 24th. Let's see what's going on with that warrant. Reset.
I've been ready to, they had 3 times to pick me up in 3 different counties and pick me up.
I tell you, right? If you have immigration issues, they're coming for you. It's up to
That's a
them.
mistake anyway.
Anyway, but I'll reset it here. We got to get you to go to Palm Beach County. We need to have it reduced to a warrant. So I don't know if the state wants to reach out to the probation officer, see if they're going to issue that warrant. Sometimes it will pop up in the system. All right. And we'll
So
reset.
when do I come back again?
All right.
I'm sorry.
What?
I didn't hear you. I'm sorry.
You keep talking at the same time I am. Your case is reset for next Tuesday. I want to see if the judge signed a warrant to try and get you out of here.
Okay. Thank you.
Sir. Andre Andre Derive.
Yes, ma'am.
Where's raise your hand on Zoom. Where are you? Thank you. Thank you, sir.
Yes, ma'am.
You have an arrest warrant from Sarasota County, Florida. It was issued May 29th of 2025. Failure to appear. It says order of arrest and commitment for driving with a suspended license. And you have a bond, it's $5,000. So if you can post a $5,000 bond, you can get out of jail. If you don't have any money for a bond, you'll have to wait up to 15 days for Sarasota County to come pick you up. Your case is reset here for July 7th to make sure you are picked up or posted a bond. All right?
July 7th, ma'am?
Have up until July 7th to get you, or you can post a bond. Have a good day.
If I don't have the bond money, I get released within the 15 days?
They're gonna pick you up if you don't post a bond.
Okay, thank you so much.
Have a nice day. Now we have the regular calendar. Francisco Ruiz for private attorney. Is somebody on Zoom? I don't know who's raising their hand on Zoom. Only if I'm on your case. Because if the attorney start, I'm not speaking to anybody's family about the young man from Friday. I'm not answering any questions. Francisco Ruiz, page 7. I have private lawyers on Zoom as well.
Just a minute, Your Honor, because who we have right now is Centron.
Huh? I thought we had lawyers on Zoom. Now this, I can't even tell who's on Zoom. We have a private lawyer for Jerry Baptiste. Mr. Hoffman is here for somebody too. For Leandro, did you get that case? Leandro Osorto as well from Mr. Hoffman. Mr. Hoffman, you can put your hand down now. We'll raise your hand when we're on your case. All right, thank you. I need those two cases after these. I'm sorry, Francisco Ruiz here, page 7?
No, Your Honor, he's not here. The person that we have is Centron, is number 23. Have to go pick him up.
We have to go get, I'm sorry, they have to go pick him up. He's not ready.
Okay, Judge.
What is your name? I'm sorry.
Nelson Rodriguez Varela.
Tired.
It's okay, Judge. Thank you. I'll wait.
I'm just putting you here in case you go to another courtroom. We have it.
No, I'm just before you.
Sorry to hear that. All right, Alejandro Cala, do you have him or no? Who is this gentleman? What page is he on?
He's number 23. His name is Centron. No.
What page is he on?
But the judge doesn't want to talk to him. That's not who they're calling.
What page?
Judge, this is
Just a
page
minute.
8. Page 8.
23
All
is
of page 8.
Francisco Ruiz.
Ruiz is on page 7, Your Honor.
My client is Francisco Fernandez Calgary.
I understand, but we don't have him yet.
So who is this gentleman so I can call?
This is Mr. He's on the same page, but his name is Centron. I don't know if you need him or not.
No.
Centron?
Jean-Louis Cintron.
Why is he being called out of turn?
Your Honor, I believe that maybe your calendar was numbered incorrectly. So this is number 23 and we need a 22.
Okay, I don't know his name. Can I have the paperwork or I'm starting with correct. Don't step aside until they get your paperwork. Start with Kenny Letter. They don't have your person. So what's the name of your client?
Yes, Judge. Alejandro Fernandez Calgary.
We have Alejandro Calgary on page 19. So the numbers are out of turn. Who did this today? Who made the calendar? That's a
She's like, this.
They're on the same page. Let's just fix it.
Your Honor, I went to go pick up Mr. Calgary.
Okay, they have to go get him. He's not here.
Thank you, Judge.
All right. Wait, let me make a note that you're here. Are you going to another courtroom?
No, I'm just.
All right. We have a little issue with the numbers and the calendar. That's the problem, but it's okay. Everything's all good. So we'll just start on page corrections out of turn. I'll say page 20, but I don't know what page it is. What number did Eric? What page do you know?
Starting with St. Ford.
I'm sorry.
St. Ford you want? Okay. Put this one back. Also, I have these private lawyers on Zoom. I can't, now, where's his, Mr. Hoffman's here for somebody on Zoom. My Zoom, I should just delete it.
I'm gonna try to help.
Leandro Osorto, I don't know what page he's on, but I need him. And I also need Jerry Baptiste. Jerry Baptiste is not on the calendar. Okay, Miss Porcio, try back later. Joseph St. Fort. Just so you know, I'm probably not going to be here. I'm probably leaving around 10-ish. So I'm trying to get through as much as I can. So line up and bring in whoever you can.
Your Honor, this is the added charge for Mr. Sankford.
Good morning. You were arrested for burglary to an unoccupied conveyance, fraudulent use of a credit card, theft of a credit card, petty theft. It's from June 6th of 2025. So let's see. It's Bank of America, vehicle burglary. She parked her car, left her purse, went to go to the ATM, and she comes back to her car and realizes her purse is not in the car anymore. Black SUV parks next to her. Then she started getting notifications on her phone of transactions at 2 Foot Locker stores and 7-Eleven. 7-Eleven in Sneaker Town, so. So there's probable cause for the charge. The officer was able to identify Mr. St. Fort. You were ordered to stay away from the alleged victim, Isabel Castillo. No contact with that alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. Stay at least 500 feet away from the victim or home, school, and place of employment. Count 1, burglary to the unoccupied conveyance is $2,500. Count 2, fraudulent use of a credit card over $100, $2,500. Count 3, theft of a credit card is $500, and count 4, petty theft, will be $500. Have a nice day.
Total $6,000, okay?
Next we have is Sheldon Niles. I'm not even gonna say a page number, so but it was around 20 or 21.
Your Honor, these are added charges.
Good morning, sir. You were arrested for improper exhibition at the jail. I will appoint the public defender's office for you. There's probable cause. Your bond's $2,500. Have a good day. Corrections, if you get any cases in for the private lawyers, just bring it, let me know and just bring them up here.
Yeah, right away.
Jones, page 22. Good morning, Mr. Jones. You were arrested for robbery by sudden snatching. I will appoint the public defender's office for you. There's probable cause for the charge. It's from June 2nd. You are ordered to stay away from Denise Kitchens, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim's home, school, and place of employment at all times. Your bond is $2,500. Have a good day. Next is Renee Alvarez, page 22. Out on bond. Is this an added or no?
Oh, Your Honor, this is first time up.
Morning, sir. You were arrested for grand theft of a vehicle. It's charged as a first-degree felony, but there's no value stated. I believe it would be a third-degree felony. Let me just review. You're also out on bond. Hold for F-25 10834. All right, so 1 minute. Okay, there's probable cause for the charge. $2,500 bond, and you'll see your judge. You'll see your judge tomorrow. I mean, you'll see your judge Monday. Have a good day. Grand theft F3. Next is Devin Lormond.
He refused, Your Honor. This is the added charge.
Your Honor, we can go ahead and
Appoint the public defender's office, waive presence, setting a bond. Count 1 has $1,000, 2 is 500. 3 will be $500. Appoint public defender's office, waiving his presence.
Your Honor, there's a hold for F 249226. He's out on probation.
If you hold for the division judge. Next we have is Carl Mitchell. Is anybody going to help me pick these up for him or no? You guys are sitting there chilling. Ashley, no? Page 23, Carl Mitchell. Oh, he has 2 cases or 1? Wait, he has 1. I'm sorry, who was the other one? This is Mr. Mitchell. Good morning. Sir, you were arrested for petty theft, 2 or more convictions. It's from May 20th. I will appoint the public defender's office for you. Let's see. Stole a scooter. So there's wait a minute. There's probable cause for grand theft. Bond is $2,500. Have a nice day.
2,500, Your Honor?
$2,500. Next is
I'm sorry, I can't.
Trevon Willis.
Sorry, which one?
Good morning, Mr. Willis. You were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you. So he entered the store. He took let's see, $500 of merchandise. Doesn't mention prior convictions. You want me to just find probable cause for petty theft? Stay away from the Old Navy store at 599 West 49th Street in Hialeah, Florida. You are not allowed to go to that store and you must stay away from there, sir. Do you understand?
Yes.
Probable cause petty theft, $500 bond.
Judge, could we ROR him since that was what would happen in misdemeanor court?
These are added charges.
Oh, I'm so sorry. $1 bond?
This is a lot different than misdemeanors.
I understand.
Yeah, but thank you for asking. It doesn't hurt to ask. Certain cases I would ROR, just so you know, like marijuana possession, it's minor.
So, Your Honor, we're going to leave it at 500 or $1?
500, yep. PC petty theft, first degree misdemeanor. Next we have is Trevon Willis.
Your Honor, we just did Mr. Trevon Willis.
So sorry, Font. Next is what? Yasmani Font. Is he here today?
Mr. Font, he refused.
All right, you want to waive his presence or there's probable cause for he's been here before. I just see petty theft.
Yes, Your Honor, we can waive.
He has 2 cases. So at F25-12722, there's probable cause for petty theft. Appoint the public defender's office, waive presence. Bond is $500. F25-12712. It's a retail theft within the 30-day one. This is more the drills. There's probable cause on this one. It's a $2,500 bond. Next is Nathaniel Harvey, page 24.
This is an added charge, Your Honor. He refused court.
If you want to, it's the first time up, but it's an added charge. I don't know if you want to waive his presence or show up on Monday if he's still here. You want to waive his presence? Or you want me to reset it?
Yeah.
It's a stolen gun.
Give me 1 second, Your Honor.
I'll do 1,000 on the gun if you want to waive his presence. It was stolen. Yeah, I'll do 1,000 on the gun if you want to waive his presence.
Yes, Your Honor, we can go ahead and waive.
1 minute. I don't know where it says he's a convicted felon on here, is it?
I don't see that either, Your
I can
Honor.
do $1 on count 2 if you want.
Please, Your Honor.
All right, appoint the public defender's office. You said what? Refused?
Yes, Your Honor.
Appoint the public defender's office, waive his presence. Count 1 will be $1,000 and count 2 will be $1.
Thank you, Your Honor.
right, next we have is David Washington, page 25. Is he still at Ward D?
Yes, Your Honor.
Let me review for probable cause. I don't know if the judge yesterday was looking for probable cause. It looks like battery on a law enforcement officer on count 1 and resisting with violence count 2. Reset it. Reset in the afternoon. Next is Livingston Martin, page 25.
He refused, Your Honor. These are added charges.
You want to waive his presence? It's battery by a detainee.
Yes, Your Honor.
There's probable cause for the charge. Appoint the public defender's office, waive presence. I'll set the bond at $1,500. Next on page 26 is James Taylor.
This is an added charge, Your Honor. He refused court.
Want to waive his presence?
Yes, Your Honor.
There's probable cause for the charge. I'll set it at $1,000. Appoint the public defender's office, waive presence. Cadrell Collins.
Added charge, refused court.
Ms. Miranda, Miranda said signed the waiver. You want to bring it back out? You want to read that?
Deal with it Monday. Can't deal with it now. Because he's bringing his pre-signed waiver. He wanted to contest, so we'll just deal with it Monday. You want us to reset it for Monday?
Well, reset it for
All right, thanks. Cadrell Collins, is he here? I'm sorry, what did you say?
He refused,
He
Your Honor.
refused added charges.
Presence.
We can waive. Judge, it doesn't seem like this person's gonna want to go forward.
I don't know. I'll set his bonds. Wait a minute. I'll set it at. I'll set it at $1,000.
$1,000's okay, Your Honor.
I'll do $1. All right.
Thank you, Your Honor.
Defender's office, waive presence, $1 bond. Now on page 27, whatever page it is, I'm not sure what it corresponds to. Ernest,
Refused, Your Honor, added charges.
all right, appoint the public defender's office, waive presence. I'm sorry, you want to waive his presence or no?
Yes, Your Honor, we can waive.
Appoint the public defender's office, waive presence. There's probable cause for the charge. Bond is $2,500. Next is Denny Pierre.
He refused added charges.
We can waive.
1 second. You want to waive presence?
Yes, Your Honor.
Thank you. All right, so appoint the public defender's office, waive presence. I don't know if it's aggravated. Let me take a look.
Judge, it just seems like a regular fight.
What, it looks like a regular battery. Let me see. The probable cause for battery by a detainee on another detainee, bonds $2,500. All right, so you have any private lawyer cases I can call? I have Mr. Osorto on page 14. Is he here? Otherwise, I got to start with the ladies.
I was out. I'm sorry, Your Honor, who were you looking for?
Good morning, Your Honor. Is it possible for me to waive my client's presence and set the bond?
No, I'm not calling anything out of turn. I'm waiting for the people to hear. They're gonna bring them in. I'm sorry, Mr. Reynoso. I'm so sorry. It's not.
Ruiz Fernandez is here.
No, is that your client? Ruiz Fernandez? Is that Francisco Ruiz? Is he there?
Yes.
Who's the boy? Got one, I'll take it.
I keep hitting myself with a news.
It's Friday.
Oh, God.
Good morning, Mr. Ruiz. Do you speak English?
Habla inglés, señor Ruiz.
No.
Spanish, I believe.
Sir, you were arrested for armed possession with intent to sell a controlled substance called Xanax.
Señor, usted fue arrestado por posesión haciendo armado para vender una sustancia controlada que se llama Xanax.
All right, so it was your attorney is present. Good morning, Mr. Rodriguez Varela. You want to say hello? Oh, does he have two cases or one?
No, Judge, my understanding is only one case. Nelson Rodriguez Orell appearing on his behalf.
Nelson Rodríguez, su abogado, está ahí a favor suyo.
There's probable cause. Anything you want to say with the search warrant?
Well, there is a search warrant. The
Probable cause. What bond do you want?
Motivo fundado. ¿Qué
I'd
fianza
like
pide?
standard on a third is he's charged under 89313A1. I'm sorry, A1. And I mean, I'm looking at it here.
Bond do you want? Give me a number.
Está pidiendo la fianza.
Fine, $10,000 bond. Probable cause. Have a nice day.
Your Honor, is that with a Nebbia or no Nebbia?
No Nebbia. He can bond out. No Nebbia.
Thank you, Judge. Appreciate that.
$10,000 de fianza sin nevia. Su abogado le explica, llámelo.
Okay, listen to your lawyer. Next is,
Escuche su abogado.
do you have Alejandro Caligari? Huh? I'm sorry, Alejandro Fernandez Caligari. He's here. Wonderful. Good
Okay,
morning.
wonderful. Thank you, Judge.
Sir, do you speak English? Yes.
Habla inglés, Caligari.
All right, sir, you got arrested for 2 counts of possession of pornography, and your attorney is here. Good morning.
Judge, good morning, Your Honor. Walter Reynoso on his behalf. Judge, I received and reviewed the arrest affidavit. We would stipulate to probable cause and ask the court to set the standard bond.
Okay, I'll find that there's probable cause for the charge, two counts.
They're third-degree felonies, Judge.
Third-degree felonies, and I will set a bond. Count 1 is $2,500 and count 2 is $2,500.
Thank you, Your Honor, for taking me out of turn. You have a wonderful weekend.
So you have a good attorney. Listen to what he tells you. Thank you.
Thank you, Your Honor.
Next is, do you have Leandro Osorto?
No, Your Honor. Can we please start with the females while we go pick them up?
Mr. Hoffman, I'm trying for you. I'm trying, all right? As soon as he's here, we'll recall it. Yaneski Navarro Jimenez.
Okay, I'll get that one too while we're going through the calendar.
Isn't that page 1? The ladies? Okay, Vanessa Flores, page 1.
That's her.
Anybody, I'll take. Good morning, ma'am. This is Miss Yaneski Navarro Jimenez. Ma'am, you were arrested for battery on a law enforcement officer. Is it Spanish or English?
¿Habla inglés o español, señora? Nada más.
English, Your Honor.
Thank you.
Okay, so I am appointing the public defender's office for you. They were taken to the hospital and there's probable cause for the charge. So I'm okay. What happened to her criminal mischief?
I only have one charge for her, Your Honor.
Oh, I'm sorry. I'm looking at the wrong paper. All right. Just the one charge. I'm going to give her pretrial. Looks like they were taking her to the hospital.
Yes, Your Honor.
Pretrial services, alternate bond, $2,500. Have a nice day.
Thank you, Your Honor. God bless.
I hope you feel better, ma'am. You got to be calm with the law enforcement.
Thank
Right?
you so much.
Next is Vanessa Flores,
I'm sorry.
page 1. Good morning, ma'am. Do you speak English? Yes. You were
Yes,
arrested
ma'am.
for aggravated battery with a deadly weapon and criminal mischief. I will appoint the public defender's office for you.
Judge, I do have a probable cause argument as far as the aggravated battery with the deadly weapon.
Go ahead.
Your Honor, there's no indication that there is any great bodily harm. Additionally, there is a basis here for a lack of intent as far as the whether or not it was intentionally to hit him or whether or not it was to escape an individual who was coming towards her car. And so we would be asking that there be no probable cause found for that.
There's probable cause for the charge. She accelerated her vehicle towards the victim. She struck the victim's legs with her vehicle. That's an aggravated battery. And criminal mischief, I guess, for throwing the metallic bottle at his car and causing paint damage. There's no value as to that. It's an M2. Yes.
Yes, Your Honor. Again, while I understand the hitting the legs, again, there was no mention of any bodily harm. And again, even though there was an acceleration,
Firearms a deadly weapon. It's the instrumentality is being used as a deadly weapon. It's not charged as serious bodily injury.
well, Judge, even then, there's no intent that this is what her actual goal was, rather than to escape a situation where somebody was coming at her.
So State, do you want to say anything or no?
She directly drove a car at somebody who was trying to talk to her after an accident, hitting them with her deadly weapon, with her vehicle.
Ma'am, there's probable cause. You don't like my ruling, file an appeal. Stay away from Jaziel Santana, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, his home and school and place of employment at all times. Also, we have video footage showing her purposefully going onto the oncoming lane, lining up her vehicle in front of the victim, and repeatedly accelerates the vehicle at the victim. That's the probable cause. It's not beyond a reasonable doubt when we're here at first appearance hearings. Doesn't look like, this is something. She has no priors that I see. State, does she have any priors?
I am looking right now. It does not look like it, other than like a misdemeanor or two from
A set of bond on count 1 of $5,000 and count 2 criminal mischief is $150. Good day, ma'am.
Marochi?
Next is Paloma Marochi.
Thank you. Thank you.
One second. Good morning, ma'am. You were arrested for aggravated battery and possession of drug paraphernalia. It's from June 19th, yesterday. I will appoint a public defender's office for you. She struck the victim with the bicycle, causing a laceration to his head and ear, and she had some drug residue. It doesn't say what kind of drug residue, so it's no PC on count 2. Probable cause on count 1. Ma'am, you are ordered to stay away from Juan Cortez, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Do you understand the stay away order, ma'am?
Yes, I do.
All right, on count 1 will be $5,000, and count 2, I'll set it at $1.
Judge, as far as for the aggravated part, as a laceration,
The bicycle, that's a jury question. If the bicycle is being used as a deadly weapon, there's enough for probable cause. The victim had a laceration to the left side of their head, excuse me, behind the ear.
So I was trying to.
I did lower and middle. I said it, instead of 7,500, I set it at 5,000.
yes, Your Honor. Thank you. Your attorney's gonna get in contact with you. Okay.
How long do you just stay here?
Your Honor, she refused court. This is the added charge. She also has a fugitive from Broward County with a no.
Want to waive her presence? It's battery. Is this Miss Kerr? That's not her. Do you want to waive her presence or you want me to reset it?
I'm sorry, who was the individual?
Aya Karwowska, she refused court. It's a battery on a corrections officer. It's an added charge.
We
You
can
wanna
go ahead and waive.
What?
We can go ahead and waive since it's an added charge.
Wait, the public defender's office waive presence. She has also a fugitive warrant. So I'll set a bond, wait a minute.
Judge, I just want to note that there could potentially be a stand your ground here. And every paragraph reads as an attempt, and then getting into a physical fight.
Give me a second to read it. Attempt is enough for a battery, or it could be an assault on a corrections officer. Let me see. I'll find probable cause for assault on the law enforcement officer, set the bond at $1,000. Okay.
Thank you, Your Honor.
Next we have is Ivis Marcial de Fuera.
These are added charges for her, Your Honor.
Morning, ma'am. Do you speak English or
Habla
Spanish?
inglés, señora, nada más que habla español.
Sir,
Spanish.
you were arrested for a case from June 10th, petty theft, 2 or more convictions. I will appoint the public defender's office for you.
Usted fue arrestada por un caso de robo menor en cuantía, junio 10, 2 o más condena, le asigno a la oficina del abogado de oficio.
Ma'am, you are ordered to stay away from the J.C. Penney store at 20505 South Dixie Highway in Cutler Bay, Florida. You are not allowed to go to that location and you must stay away from there.
Señora, tiene que mantenerse alejada de la tienda JCPenney ubicada en el 20505 South Dixie Highway en Cutler Bay, Florida. No es permitida ir a esa tienda.
All right, I'm setting a bond and it's $2,500. Have a nice day.
$2,500 de fianza. Tenga buen día, señora.
Corrections, let me know when Mr. Sorrell visits us.
Your Honor.
What?
Your Honor, once we're done with the female.
All right.
Llama cuando regresas, okay? We have Ms. Thrope, Your Honor.
You know, he was covering Judge McCuss. Now he's trying to finish his calendar, so he should be here fairly soon. Correct. That's what
Good morning, Miss Thorpe. You were arrested for burglary to an occupied what? You're arrested for burglary to an occupied dwelling, a second-degree felony, and grand theft, a second-degree felony. This is from June 11th. I will appoint the public defender's office for you. No, I guess.
No probable cause argument with regards to the grand theft. However, I would be arguing that there was no burglary of an occupied dwelling.
So it looks like he met the victim earlier that night at the Coco nightclub. They went and got some Jamaican food, went back to the victim's home. Then he drank some brisk iced tea, and after that, he began experiencing abnormal fatigue and drowsiness. Let's just say when he woke up, his apartment was ransacked, and he's lost over $25,000 of merchandise, jewelry, IDs, bank cards, Ring doorbell camera. There's probable cause. Let me just see something for the count 2. I agree with you as to the burglary. So count 1, actually, ma'am, you are ordered to stay away from the alleged victim whose initials are O. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim's home, school, and place of employment at all times. So count 1, burglary. I don't believe there's any probable cause. The state files is saying that she entered under like a false pretense, but I don't think that's sufficient for probable cause. So count 1, do you want $1 or you want an ROR? I mean, a
Yeah,
release
Judge.
outright,
Yes, Judge, I'd be asking for release outright.
release outright.
No piece.
Count two, there is probable cause for grand theft. That bond is $75,000. Stay away from the victim. Good day, ma'am.
You're good to go.
7,500, sorry, 7,500, count two. Release that right, count one, 7,500, count two. Next case. Inez Burrows, page 3.
Let's go. Borrow.
Good morning.
Good morning, ma'am. You were arrested for aggravated battery. I will appoint the public defender's office for you. There is probable cause for the charge. She lunged at the victim, first with a curling iron, then with a knife, and she actually cut the victim on his upper arm and chest area. So there's probable cause for aggravated battery. You are ordered to stay away from Anthony Anderson, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times.
Yes.
Bond.
Judge, just based on the fact that he borrowed her possession and then effectively stole it and gave it away, would Your Honor be inclined to lower the bond?
Okay, because he didn't, 1 minute.
Because he committed a theft.
I'll set, bond is $5,000. Good luck to you, ma'am. Does she have money for a bond? I can give her house arrest.
Do you have a home?
Does she have money to post the bond or you want house arrest?
Judge, if we could do house arrest alternate bond?
All right, house arrest with a GPS monitor. Alternate bond is $5,000. It will be level 3 house arrest with a curfew from 11 p.m. to 6 a.m.
Thank you, Your Honor.
Good day, ma'am.
We can change.
Wow, that was very nice of that judge. I mean, house arrest with the curfew. I don't know how that works. Because if you are on house arrest, you already are home. I don't know. It is weird. But anyway, I mean, I really like this judge. But if we want to do that 1-day trial, even speed up, I think we have to start watching it now. Before I want to see if I can finish like at around dinner time for me, so I can still have the evening with the garden but and everything, and then we'll be back on normal scheduled trial on Monday. What is the Judge Mandy Glazer, William? Is Judge Mandy? I'll put on a chat. Hang on, 1 second. Judge Mandy Glazer. So the trial that we're gonna watch is on Judge David Wolf. We watch this judge quite regularly when we are court hopping, but yeah, he's actually doing a 1-day trial. There's literally openings, closings, witnessings, verdicts, all in 1 day, all in a span of 6 hours. Which is, you know, bang bang done that. The person that is on trial, his name is Jeremy Jacqueline. That doesn't get confusing. So, no, she's from Miami, William. Unless that's her name, Mandy, Wisconsin, but she's from Miami. The 3 charges that he's facing is the charges that he's facing is 3. One of possession of heroin, 1 possession of meth, and then another possession of drug paraphernalia. So that's the 3 charges that he's facing. So basically, the whole trial is literally in 1 day. We're gonna be watching at 1.25. I think that's a good speed. Judge Wolf stream. So we're gonna talk about it a little bit, and then we'll have a very quick verdict as well, which is good. I like it. Hopefully, I think the sound will be fine. I will try to adjust as much as I can. But I mean, and we can skip this part. We can literally, when the judge comes on, and then here you go. I think because even the jury instructions on this one is going to be quick, which we like because
you can sit anywhere you want to now. No assigned seating at this time.
I really like.
Find you a comfortable seat and claim it.
Let's
So,
put
particular
prayers
C. So the jury, the defendant, Jeremy Jack Lynn, is charged in counts 1 and 2 in the indictment with the crime of possession of a controlled substance with intent to sell or deliver. In count 3, the defendant is charged with possession of drug paraphernalia. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of these proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision. But now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing these charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime, and it is not evidence of anything. The defendant is charged in counts 1 and 2 in the indictment with possession of a controlled substance with intent to sell or deliver. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant knowingly possessed a controlled substance and intended to deliver or sell such controlled substance, and that the controlled substance was scheduled controlled substance. The defendant is charged in count 3 in the indictment with possession of drug paraphernalia. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant used or possessed with intent to use drug paraphernalia. The defendant has pled not guilty to the charge. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about what the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if he or she should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Humphreys County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defendant will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you're to use in reaching your verdict. After you hear my instructions, I will select and excuse the alternate juror, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify. Then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question or the reason that it could not be asked, please ask after our court is adjourned and I will attempt to explain it to you. An important part of your
Okay, I thought the instructions were going to be quicker, but it's not. So let's just jump to the opening statements. That'll be quicker.
In this case, gentlemen.
In the Circuit Court of Humphreys County, Tennessee at Waverly, June term, Grand Jury 2020. The grand jurors of Humphreys County, Tennessee, duly elected, impaneled, and sworn, and charged to inquire, find that on or about March 12, 2020, in Humphreys County, Tennessee, Jeremy Jack Lynn did unlawfully, knowingly, intentionally, and feloniously possess with intent to sell or deliver a controlled substance, heroin, a Schedule I drug, in violation of TCA 39-17-417, all of which is against the peace and dignity of the state of Tennessee. Count 2. And the grand jurors do further say that on or about March 12, 2020, and in Humphreys County, Tennessee, Jeremy Jack Lynn did unlawfully, knowingly, and feloniously possess with the intent to sell and or deliver a controlled substance, methamphetamine, a Schedule II drug, 0.5 grams or more, in violation of TCA 39-17-434, all of which is against the peace and dignity of the state of Tennessee. Count 3. And the grand jurors do further say that on or about March 12, 2020, and in Humphreys County, Tennessee, Jeremy Jack Lynn did unlawfully use or possess with intent to use drug paraphernalia, digital scales to plant, propagate, cultivate, grow, harvest, manufacture, compound, convert, produce, process, prepare, test, analyze, pack, repack, store, contain, conceal, inject, ingest, inhale, or otherwise introduce into the human body a controlled substance or controlled substance analog in violation of TCA 39-17-425, all of which is against the peace and dignity of the state of Tennessee.
Baker, I'm sorry.
Mr. Lynn, enter a plea of not guilty, Judge.
Plea of not guilty. All right, ladies and gentlemen, the next step will be for the lawyers to make their opening statements. So the state will have an opportunity to go first.
Ladies and gentlemen, I'm just going to talk to you briefly about what the state is expecting to be able to prove to you today. We're going to start out with Officer Browning, who's going to testify first. He is the officer who made the stop, who interacted with the defendant back in March of 2020. He's going to testify about what happened, about his interaction with the defendant, and what he found. And we are going to watch his body cam footage of that incident as well, so that you can see with your own eyes what was transpired that day. We will hear from another officer on the scene, Officer David Ross. He's now retired, but he's going to testify as well because he arrived on the scene and assisted with the stop and everything that happened at that point. We will further hear from the evidence custodian who used to work with the city of Waverly at that point in time. He was the individual responsible for securing and protecting the evidence that was collected. He'll testify about that process. Lastly, you will hear from the TBI agent who analyzed the drugs, and he will testify about the amount that he analyzed, how much it was. He will talk about what those drugs do, as well as his process for analyzing and how he came to discover how much drugs there were. You will also be shown the drugs themselves. They'll be in sealed packages, but I will show those to you as part of the process. You will get to examine those if you so wish. You will also see the scale that receives and see. And you'll get to look at that if you want. We hope that when we show you all that evidence and you see yourself what was happening and you compare the testimony, that you will come to the conclusion that the defendant is in fact guilty of heroin, meth, and drug paraphernalia. The heroin and meth, the state is alleging, was for resale, not for the simple possession. In other words, not for his own personal use that he was selling those drugs. The officer will testify that he found drug paraphernalia. He will testify that the amount of drugs that he found was consistent with sales, not with personal use. You'll hear all of that. And the state hopes that after hearing all that, you will come to the decision to find Mr. Lynn guilty.
Baker, you may address the jury.
Judge, I'd like to reserve mine until our opening that's fine. And I'm probably I need a very brief jury. Something come up to my attention. I probably need to work it.
All right, ladies and gentlemen, this is what I warned you about. We'll have opportunities for you to go across to the jury room and allow to hear whatever the issue is. So thank you. If you'll step across the hallway, please.
Judge, as we were sitting there, you're reading the jury instructions. Unbeknownst to me, Mr. Lynn, I advised him, well, Mr. McLeod's standing in for Mr. Hornick today because he was, out. And somehow, apparently, it comes to my attention, Mr. Lynn informs me that Mr. Hornick not only represented him in the past, conducted a jury trial on his behalf. I don't know what the court wants to do with that. To me, that's a direct conflict of interest with the DA's office.
I don't see Mr. Hornick here in the courtroom.
Well, my opinion, because I've been kind of puzzled why made a couple of plea offers and they were so extreme, why that was, and I don't know what
So your motion is basically, you're making a motion to disqualify the district attorney's office from this case after the jury's been sworn and opening statements and the indictment has been read.
I'm not. I would like Mr. Lynn to make that decision because to me, somebody told me, hey, the district attorney's office is prosecuting, used to represent you. As a matter of fact,
the entire district attorney's office did not represent Mr. Lynn. One particular assistant district attorney did, apparently from what you're telling me. And Mr. Lynn, I'm assuming, has known that from day one in this case. And Mr. Lynn had the obligation, if he chose to raise that on a timely basis before this case went to trial. I find that Mr. Hornick, who is out with having had surgery, is not involved in this case. General McLeod, have you ever represented Mr. Lynn?
No, Your
I don't know what it had to do with Mr. McLeod. That was kind of alarming.
Therein answers your question. It doesn't have anything to do with the district attorney who's trying this case. Therefore, I'm going to go ahead and consider this as a motion to disqualify, and I am overruling that motion.
Okay, I didn't want this.
I understand you wanted to make a record of it, and I'm just simply telling you there's no basis in fact or in law for that to happen. So, all right, we've already requested the rules, so if there are any other witnesses, they're supposed to be outside of the courtroom, correct? All right, then we may proceed with bringing the jury back.
Yeah, these are not.
All right, that's fine.
Judge, one of the jurors requested to use the restroom if you could.
Okay.
So that.
This judge had enough. This judge just like move on. Like no, just man. He's trying. He's doing his best for his clients, So he's just doing.
I remind you, sit anywhere you want. It's not like musical chairs where everybody has to grab one.
I'm going to move over here when I start testifying.
Okay, good idea. This is
Judge, I'm sorry. I think Mr. Baker is asking me a question about something that I think the jury should, I hate to say it, make him step out because he brings it to my attention that I'm not aware of.
You couldn't.
I know, I'm sorry.
Step across the way. better than going to an exercise class, I guess. Oh, right.
Mr. Baker's telling me he don't have the body cam footage of Officer Browning's stop, but it's been released to him. And
Repeat that now.
Mr. Baker's telling me that he does not have and never has received, I guess, body cam footage of Officer Browning. And that's been turned over to him for several years now, so I'm not sure. I'm just trying to verify that it has been released to him, but I know it has.
The body cam they released to me was from Officer Ross.
Your Honor, it's in one zip file. One zip file. That is how a zip file was released to Mr. Baker. It gets the download button. It downloads all videos. That's how I got it. That's how I got it for this trial.
I have the download here on the thumb drive, the entire thing. She claims that there was 4 videos, which
I mean, there's 4 links. When you click on the open up, it's 4 links. We agree on that.
When do you intend to introduce this video?
And then when I call Officer Brown.
And that'll be your first witness? Then you have it available for Mr. Baker and his client to review?
Absolutely.
You've seen a body cam footage from a different officer. You just are claiming, or not claiming, but you're saying you have not seen the one that this officer had. Is that correct?
No, I haven't seen a body cam. What I have in the zip file, the compressed file, is 2 files. One that contains 3 video links. 2 is car cams. 1 has no video. Video report that I guess maybe that was uploaded is just a folder with a photograph in it. There's no video. So there was 3 file uploads in that 1 file. 2 have separate folders, video from car. You have a 3rd that has a photograph in it, which might have supposed to have been a video link, but it's not. And then you have another file that has a video file, but that's not a body cam. And then the other officer, there is a body cam file in the 2 links, the 2 compressed folders that they sent us. So we don't have a body cam from Officer Brown.
No, could I don't know if it's possible for you to approach the show, and he's welcome to come too, to show what we have and what we released.
Well, I'm going to send this folks to lunch early, and you're going to show him that video body cam footage that's in question, and that will, in my opinion, suffice, simply because of the fact that the discovery method that has been engaged in by the state of Tennessee, the district attorney's office, is to open their file and allow all by access. A defendant has the opportunity to access all of the information in the state's file through that electronic portal. If there was any sort of problem with that, then that would be incumbent to raise before this trial started. Secondly, it would be, in my opinion, if there was no body cam footage that was in the discovery that the defendant had, might raise a question as to whether such body cam footage existed. In any event, I think that whatever the problem was can be solved by having Mr. Baker and his client review the body cam footage prior to introducing it. And if you need to put it on the big screen, then you can put it on the big screen and let him see it, and then we'll go from there.
Yes, sir.
I know.
Well, for the record, you said something that said, well, that's the procedure. That assumes that when everybody uses the internet, let's say you download a file folder. How do you know what the contents of that folder was or was supposed to be?
Mr. Baker, that could be true of every criminal case where the district attorney utilizes this access portal. My point is that if there's some issue about evidence, that's typically raised before the trial starts. And as a result, I am of the opinion that the safest way to proceed is to allow the playing of that video for you and your client. How long is the video? All right, then this will be your turn. The 2 of you, this will be your lunch hour. So if you brought anything to snack on, you go for it. Because when I'm going to send the jury on to lunch, and then when at 12 o'clock when they return, we'll be ready to proceed. I'll give it 12:15. How about that? That'll give you 15 minutes to grab something. So bring the jury in, please.
Judge is not happy. You can see in his face that he's not happy. That's like, this is something that they shouldn't have done before the trial comes. So they're literally wasting an hour of the trial. Well, it's not wasting this. They go to lunch early, but still. I know, Cindy, it's so yummy. I really like it. But this is the thing. I've been trying.
Thank you, ladies and gentlemen, for your patience. You know, there are trials. Sometimes we got one missing, and we got them. Okay, we have trials that go really smoothly. I mean, it's like clockwork, like that. And then we have trials that don't go smoothly and seem to be snake bit. This is one of those second trials, the types of trials. An issue has arisen that I need to fix, so to speak, or to address. And as a result, I'm going to go ahead and send you to an early lunch so that you can go on and you don't have to sit around here waiting for us in the jury room. But I'm going to go ahead and tell you, go ahead and take an early lunch. Be back here at 12:15, and we'll start at 12:15 with the proof. Okay? So we'll remind you of your instructions about not thinking about this case. Don't try to wonder what's going on. Just trust me when I tell you it's just something that I need to deal with, and we'll come back to you at 12:15. Okay. When you come back, gather in the jury room rather than in the courtroom. Okay. All right, y'all go ahead and go to lunch, and we'll see you at 12:15. You're welcome to keep that. That is your copy of the instructions, and you can have it, keep it. You can have it as a souvenir or whatever you'd like to do. So let's go out, if you don't mind going out this way.
Yeah, don't go out through the camera way, guys. To go throughout the. I know it does, Janie. Thank you very much. Hello. Hi. Good morning. Yeah, it does very. Yeah.
We're going to
exactly.
play this. I'm going to sit here while you play this body cam footage. Can you play it on the large screen?
Yes, sir. That's correct.
Let's do that. Obviously, I need to review it in case there's some issue that arises.
Yes.
You take me off. You can take me off the big screen.
I'm not sure if we are going to be able to watch that, though. That's the thing. Let me see. Oh, we are kind of. Let's go fast forward.
I'm just asking about this file. I mean, I don't need all that attitude from the DA's office.
I think Mr. Owen thinks to chill out.
Children, behave. Stop the nonsense back and forth. Let's get this fixed so that we can start with this trial. This all should have been settled in pre-trial. It's not been, so we're going to deal with it right now.
That's true.
Let's keep your comments back and forth to a minimum. So.
I have, okay, and there's something I need to do to get it. There is control and the Windows button. Get that. This is always the part that gives me trouble. Here, hopefully it'll get that.
Okay, they're still turning on the thing. Okay, let's try to.
Yes, that's the one we chosen as the best connection.
Okay.
And then you find the circuit TV window, that Windows button and P. They get the word, and then you have to connect to the. Yes, you see it? I connect to the duplicate. I believe that's right. Should pop up there. It should. You know, we also talked about putting the flash drive. Yes. That last time I think that was the way we got it.
This part, this is not.
It takes.
I want to watch it before the. There you go.
Oh no! Yeah, I know you made it. Still do the sales, still in. I know we did. You know, fix your eye. But be honest. All right. Don't be digging around, buddy. No, don't be digging around. Put your hand right here for me, please. All right. Sit right over here. Sit right here. Stand by him. I'll stand proud.
I didn't know. You just said stand by here.
What's that? What's your day up?
11587
115
87
87
37
37.
41. That's the first time I've ever named it.
All right, so I'll fix search, fuck you out. So let's be honest up front if there is anything. Nobody has nothing more to go to jail over. You have anything on you?
No.
I'll fix call the jail. They're gonna bring me a female officer down here.
Okay.
What about you, Jay?
I'm
You got a
not
little
search.
because they said digital scales just fell out of that truck.
Yeah, but those are mine.
I understand that, but you're in the vehicle. That makes everything in that vehicle, including drivers, can be searched. Okay?
No, I've done nothing.
You put anything in there? Breaking point, man. I give you a chance to be honest with me. My head, yeah. We so nervous about it.
I'm not nervous. I'm pissed off.
Why?
Because it's happening.
You act like you just got busted twice in 1 week. John,
I did not get busted twice in 1 week. I'll correct yourself.
Once?
Yes.
Okay. You want to it? Well, I was going to run the dog around the vehicle, but when he got out, digital scales fell out. So now we just start. You got anything? How many starts you got nailed or anything? Just put your hands on. You want to be with John's face by the time we got the Hubble. She said Hubble still has her license. He wouldn't buy you no more license?
What?
Hubble wouldn't buy you no more license?
No.
Is there anything you do? Yeah, that's fine. Why ain't talking about like that? That's some good tweets. You got your boot? Might get them up. You ain't got it. You got it. Guess I was your scales to talk for that. Anything on you?
No, sir.
Ready to pick for me? I'm gonna check your pockets, okay? Got more pockets?
No.
All right, is there anything in the vehicle?
No.
All right. Man, you need to raise your hand picked up, okay?
But you can't search either. I don't know.
I can't search.
Oh, really?
Yeah.
Well, there's nothing in it.
Okay. I fix take a look and I'll grab my glove. Step in front. Jack, you stand in front. Put your step back in the pocket if you want to, man. Couple. No problem, bro. Barely, like, yeah, no problem.
Whatever. I mean, I have it all.
Tell her, Jack.
The whole truck.
Jack is awful nervous. All right. Who's she? I don't know where to go. Okay, Renee. They did, ain't he? Yeah, thought so. Sorry from granddaughter. So what's your name again? Here. Not the Garner with a G. Garner. Well, I dealt with Jack quite a bit. I ain't never seen him get that nervous acting, you know what I'm saying? Was he like that? Why? I really want to know. He's fixed to go to jail. But that's all where you been? Yeah, thank you. My man would have got that though. That skill would have fell out. I don't know who that.
Yeah.
Why they all use it now? That's what they all use now, though, you know? Yeah. Rocks. They all use the rocks. There it is. Well, let's see how easy people throw shit about. They don't want to do it first. Depending on what you do. Yeah. So, man, you already know what we're found. So, there's some scales there. Not that one on. You know, you had it. What are they? Huh? No, what are they? Good. Where you living at? Huh? Like, yeah, okay. I'll hit Gab. I'll hit Gab on, alright? You ain't alright. I ain't worried about that. If you have fun, you yeah, okay. Fair enough. Alright, okay. We'll put everything in trust. I do your one. Keep it. Okay. Check out TV, you have it. You want to get all this jump back up? You want a cigarette? You need to got it. I told off the rod one thing I said. I didn't jack a lot. He's off the nervous now. I'll do that now. Who's on this truck? Can you call her? I don't know yet. I just find it awful coincidence that you're with somebody every time they got something on. They told me you didn't know. They said you didn't know, but I still find it awful coincidental that you're.
I mean, I got a great thing. But I don't do anything wrong. I'm actually sober.
3 more nights. You care if I leave that knife in the truck? Or you want to take a weed? Want to take a weed? All right. I'm going to find your DL. I'll cut you loose, I guess.
What are you arrested for?
Let's just check the food reset.
What kind of
Possession of meth for resale. Is that what that is? Sit back here. I'll just smoke a cigarette with him and I'm going to go check her DL. Yeah. What's your name again? Hey, Bart. 40. 42. Met the darn? 327. 92. You stay from my car, Jack. I'll put you in on back up. You find me a deal for Samantha Garner, 327, 1992. Also, Jeremy Jacqueline. We've been here all day, pals. She sure is good at playing dumb, ain't she? I mean, she ain't good at it. She sure does like to play it.
We don't need to watch the rest of this. I've got the rest of this.
All right, then let's stop the video.
Open bowl. It's kind of like a bus
Where did General McLeod go?
got a cover over the light.
Let me turn our lights on first. All right, based on that review, the court's going to adjourn for lunch. Do you have anything else to say about that? I mean, we need General McLeod in here for this, I guess. Is there anything else before we break for lunch? All right, we'll be in recess until 12:15.
Okay, and the power of being able to skip is we can skip this time. So is gone. Oh, is back. Hang on.
Mr. Baker, as a defendant's attorney, has requested to say or reserve his opening statement to the close of the state's proof. So we'll allow him to do that, and we'll let the state go forward with their first witness.
Thank you, Judge. State Counsel Chris Brown.
Sorry, it was just funny that the subtitle said that the state was calling Chris Brown. I don't think that is the name of the witness. Probably that's what it just captured. But that reminded me that Chris Brown had a hearing this morning in the UK in London, and I have a little bit of a short of him outside of the court that a friend was able to send me. So check it out. But it's just talking about that. Nothing really happened in that courtroom. Was just him pleading not guilty to the charges that he's facing, and has a hearing again next month. I think it's July 11th, and then his trial, you won't believe, but it's set for October of next year, not this year, next year. So literally a whole more than a year to go into his trial. So that's just gonna be crazy. That was just a little bit of an update on the Chris Brown situation because of they mentioned it.
Solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Thank you. Have a seat, please. Oh, Miss Craig.
Hold on, we're waiting. You can go ahead and have a seat, but we were missing an essential person. So.
She's so little. What I didn't.
Yeah, we forgot. Everybody get something to eat. Let's go ahead and step over there until we find out where our court reporter is, if you will. Sorry about this.
Oh wow, we can see the jury. Look at that. Oh wow, and the court report. Uh-oh. Oh, we found the guard
Everybody
report.
come back in.
Everybody go out.
Sorry about I should have checked with Pam before I started back with court. Make sure you were here. So I apologize. It's my fault.
Jury. Yeah, Judge, a little bit too late there. We've already saw the jury.
I'm gonna move over here.
Please feel free.
Oh, that was funny. Sorry, that was hilarious.
I'm blocking anybody. I sit right here.
Okay.
All right, Mr. McLeod.
Mr. Browning, can you state your full name for me, please?
My full name is Christopher Browning.
And who were you employed with back in March 12, 2020?
I work for the Waverly Police Department.
And about how long had you been working for them at this time?
About 8 years in 2020.
Can you tell the court where you came into contact with the defendant, Mr. Lynn?
I came into contact with Mr. Lynn on a traffic stop that I conducted on a older model Chevrolet truck for a light law violation and registration violation.
And where did you pull them over at?
The traffic stop took place on Highway 70 near South Railroad Street. That would be where the concrete plant is. If you aren't familiar.
And is that in Humphreys County?
It is in Humphreys County.
So there was a light law violation?
There was multiple light law violations and registration. The tail lights on the truck were flickering and not working properly. And then the light on the license plate, the bulb was dangling down and it was projecting the white light to the rear of the vehicle lights in forward motion, which is a violation.
And who did you identify as the driver of the vehicle?
The driver was identified as a female, Samantha Gardner.
And her passenger?
The passenger was Jeremy Jacqueline.
And did you talk to Garner and explain why you stopped her?
I spoke with Gardner, explained to her why I stopped her. At some point during conversation, she acknowledged that she had been having some issues with the wiring on the truck.
And did you ask her any questions about anything in the vehicle or anything?
I did. I had Gardner step out of the vehicle because I wanted to show her what was wrong with the license plate. And then we went into the conversation where I asked her if there was anything illegal in the vehicle as well.
What did she say?
When I asked her if there was anything illegal in the vehicle, her first response was yes.
And did she correct herself?
And then she corrected herself and said she thought I meant not illegal.
Did you call another officer at that point in time?
I did. At that time, I requested K9 Officer Ross to start coming my way toward the scene.
What were you going to do with the dog?
My plan was to, there's a lot of stuff going on, such as the vehicle belonged to a person had deceased. And I heard acknowledging that there was illegal stuff in there originally. I was going to use the dog to do what we call a canine pre-air sniff of the vehicle.
And at that point, did you speak to Mr. Lynn?
I did. I went to the passenger side to remove Mr. Lynn from the vehicle.
And what happened when he came and stepped out?
When Mr. Lynn went to open the door, it said a diesel scale fell out of his lap onto the asphalt.
And when you, in your training and experience as a police officer, what are those digital scales normally used for?
They're normally used to measure weights of drugs for resale.
And at that point, did you decide to search the vehicle?
I did at that point. I determined there was no probable cause to conduct a search of documents in the vehicle.
And when you searched the vehicle, what did you find?
In the passenger side door next to where Jeremy Jacqueline was sitting, in the pocket, there was a black zip-up glass container, which with sunglasses in. Inside that container were 3 hypodermic needles, a baggie with about a half ounce of white crystal substance later identified as methamphetamine, and another small amount that was identified as heroin.
Did you find, you said you found the scales and needles?
Yes.
Did you later find any cash on Mr.
Mr. Lynn had, I believe, $237 in his pocket.
Now, in your training and experience as a police officer, can you explain to the jury how much in grams, you said a half ounce of meth would be?
So I think a half ounce is about 14 grams. Of course, just looking at it, you don't really know for sure it's a half ounce. That's what it looked like. The total TBI weight, I believe, was 12 point something grams. A user uses meth and heroin by point. They use 0.1 gram at a time. So 8 gram would be 10 highs. He had enough for at least 140 hits, or 120. 120.
You said you had enough for 120 hits?
Yes.
Okay. And in your training and experience as a police officer, do individuals who are addicts who are simply using, do they have that amount normally?
Objection leading and objection calls for opinion testimony.
Well, let's first deal with this, sustained as to the leading. Rephrase your question.
In your training and experience as a police officer, what is the typical amount that a user of methamphetamine or other drugs have on?
For my training,
that training and experience has not been established, and that's not a substitute for proof. That's trying to get a presumption.
You're going to make an objection, stand up.
That's not, one, that is not, training and experience has not been established. 2, that opinion testimony is not a substitute for proof. If they're trying to prove some type of intent, that requires proof, not opinion testimony. Opinion testimony is only to help guide a jury. In the alternative, I'd ask for a limited instruction on that.
No, your response?
Judge, I'm happy to establish further training as far as Mr. Browning's qualifications.
Well, I would sustain the objection based on the fact that he's not yet been qualified as to the training and experience that you're referring to. So.
Yes, Judge, I'll back up and do that. Mr. Browning, where did you go to the academy? Please.
I went to Toledo and Donaldson.
How long was that program?
10 weeks.
10 weeks?
Yes, ma'am.
Okay. And were you trained on anything relating to drugs in that program?
I was trained on the use and identification of drugs.
You were?
Yes.
Okay. So you were taught how to identify drugs?
Yes.
As a police officer?
Yes, ma'am.
And were you trained as to how to field test these drugs?
I was. We do not field test though due to the fentanyl and the risk of exposure on the side of the street to us.
But at that time you were trained to do
Yes.
And how long had you been a police officer?
8 years in 2020.
Did you have any other specialized training or anything?
Yes, I've been to drug interdiction training, narcotics training, and continue training every year on the use of drugs. Also, I've been through ARIDE, which is prevents roadside drug enforcement for DUI and stuff. So.
And as a police officer working for the city of Waverly, did you commonly or ordinarily make arrests related to drugs?
Yes.
How many arrests related to drugs would you estimate that you made during your time as a police officer?
Yes. I'll say at least 30 a year.
At least 30?
Yes, ma'am.
And I'm not asking for an expert opinion. I'm asking during your training and experience as a police officer, having done those things, were you able to distinguish patterns between users and those who deal?
Yes, ma'am. Most of the time, a drug addict would typically just have a half gram or
I
less.
will object to you. You haven't ruled on the qualifications yet. Now he's testifying.
I will rule on that now. I find that he is qualified through training and experience to give an opinion as to what his experience has indicated to him as the distinction between a person alleged to be a dealer and a person who is a private individual using it. Ladies and gentlemen, that's just his opinion as to that, and I'm allowing it based on his training. It's up for you to decide the ultimate issue as to whether or not this defendant was guilty of possession for resale or whether he was guilty of simple possession. But this officer is giving you his experience and his training to indicate what his opinion was on that.
Yes, most of my arrests are usually drug addicts who have small amounts, less than half a gram. Most times just a little bit of dust, and they're not even that because they use such a little amount to get high. Anytime it's over that, it's usually a dealer, and there's always scales that complement that as well to help with the resale.
And in this case, what were the different types of drugs that were actually found here?
So there was the TBI report come back. There was heroin and cocaine that was mixed together. 0.7 something grams, which would be enough for 7 resales or 7 highs. Methamphetamine, 12 point something grams, which is enough for 120 highs or 120 resales.
And do you know the street price for that, like every sale or hit at that time, the average?
It's hard to really trace that because a lot dictate that. I've seen a half a gram be $150 at times, and I've seen a half a gram be $50.
So it could vary depending on the time.
Yes.
And did you find any meth anywhere else on Mr. Lynn's person?
Yes, prior to taking Mr. Lynn to the jail, I always try to give him an opportunity if they have anything on him to let me have it, because once it goes into the jail, it becomes another felony for contraband. And then he gave me some more meth that he had on him, less than, probably around half a gram or less.
Who took responsibility for the rest of the drug?
Once the drugs are found and logged into evidence, they're locked into the evidence locker. The evidence custodian, which then was Detective Bolton. He collects those drugs, and he's responsible for taking them to the TBI crime lab to have them processed.
Oh, I think you may have misunderstood. I was asking on the scene, which of the 2 individuals in the vehicle took responsibility for those drugs?
Mr. Lynn took responsibility for those on the scene. He made comment that, he know that Gardner had no idea that the drugs were in the vehicle. Gardner also stated she did not know anything about the drugs in the vehicle as well.
And based on everything that you found, did you charge Mr. Lynn with possession of the meth and it was heroin for sale?
I did. Once everything was collected, I obtained warrants on Mr. Lynn.
And also charged him with drug heroin?
Yes, ma'am.
And why did you choose to charge him with possession of those things for sale as opposed to just possession?
Because of the amount he had was more than what a typical drug addict, from my experience that I deal with, usually have. And plus the scales to go with it shows that his intent, what to me was to be.
I'm going to objection testify what that shows as intent.
He did say to me, in your opinion.
Right, to me.
Well, the objection is, as the question was asking why she charged him, and he's giving an answer to why he charged him. But again, ladies and gentlemen, that statement is being allowed only, and I'm overruling the objection only because of the fact that the question was asking him why did he charge him as a certain with a certain charge, and he's answering, as to why he took that action.
At this time, I would like to show the evidence to the jury.
All right, is this the video?
Oh, this is the drugs.
Oh, I'm sorry.
And the scales.
That's right.
You want to approach the witness?
Right.
Officer Browning, can you please identify this package?
This is a set of digital scales that fell out of Mr. Lynn's lap. During the time, I also checked the scales to make sure they were operable and working, and they were working in the vehicle. You'll see that I turned them on to verify that.
And Your Honor, I'd like to submit that as exhibit 1.
All right, exhibit 1. You have them in your possession. Right.
Can you identify these 3 packages, please?
So this first one here is approximately 12 point something grams of methamphetamine. It's a white crystal-like substance. The second one is approximately half a gram of methamphetamine. And this third one is approximately a half a gram, this was the one that come back with cocaine and heroin mixing together, and it's like 0.74 grams.
Sorry, how many grams?
0.74, I believe, is what the TBI form says.
And Your Honor, at this time, I would like to submit that as collective exhibit 2.
All right, exhibit 2 collective.
And I'll back up to, you were testifying earlier about Mr. Portner being the evidence custodian. So going back to that, when you conducted your investigation, you seized the drugs and the scales. What did you do with them then?
They were taken back to the police department. We then log them in and secure them into an evidence bag and seal them off. After that, they go into an evidence drop box, which is locked and secured as well. And then Detective Fortner comes and retrieves those items. He takes them, he processes them into the evidence. And then when it's time to take them to the crime lab, he places them again, signs them out, and takes them to the crime lab to have them tested by TBI.
And why are we not showing the jury the needles were seized today?
We don't take any needles into evidence due to the biohazard risk. It's just not worth having in our facility.
What do you do with those?
They're disposed of. They're a sharps container, and whoever we can get to come get them.
And the cash that was seized, what did you do with that?
It was logged into evidence as well.
And where is it now?
We don't store cash long term into evidence, and it gets put into the drug account until there's a disposition for it.
Is that where it is now?
That is where it is now.
All right, this time I will pay the back.
All right.
Well, I'll pay the dash cam first to show us the stop, and then start with the
We'll turn the lights off.
There's no sound on the speed.
I was just gonna say, because this is the same body camera.
Is this? Do you recognize this body cam or this dash cam?
I do.
Yeah.
Is that your dash cam from your vehicle?
That is my dash cam from car 187, which was the marketing that I was driving in that time truck.
And this footage is from March 12th of 2020.
That footage is from March 12th, 2020.
So I think this part of the body camera has no video. That's why I'm talking, and that's what I was gonna say, because if this is the same body camera that they had earlier that we kind of saw on the other angle, I was just gonna say I was like probably gonna skip it because we already saw the body camera. Even though this angle is a better angle and it's a little bit better, but we'll see how it goes. And if it is the same body camera, we might speed it up a little bit more, but I think right now he's just driving to it. But we were saying earlier that he found that the defendant had a scale with him when they got stopped. That is no bueno. That is absolutely no bueno. When the sound is kicking in now. When they have a scale, it's not good, because that clearly indicates something that they're not doing correctly, the defendant, and you guys know what I mean. I think you guys do. I don't know.
Officer Browning, looking at that video, can you tell us which tail light?
So before she came up to the stop sign, the one on the passenger side did not light up, or something happened where it didn't work properly then. When she stopped, it did work properly, but also if you look right under the license plate, there's a white loose bulb hanging down there that's dangling that was flashing back and forth as she was going.
And that was one of the reasons you stopped her?
Yes.
Now, this video is not going to have any voice of the interactions or anything, correct?
Correct, it will not have any, that's just strictly the dash cam, the body cam collects all the interactions.
So it's okay if you play the back, so I'll be able to hear you.
Yeah, I think this is the same body camera that we were watching earlier. It does seem like the same format.
Hurry up. Lost right away from this car. So for two reasons. One, it looks like your brake light on the passenger side might not be working.
It's working, it's one light out, but
Okay.
my running light and my brake light work.
Okay. The next thing is your tag light.
I've got one tag light. The state of Tennessee is only have one tag light.
You're correct, but it's not, that's got to be covered. You get the whole open bulb. So it's got, you
The
need,
open bulb?
yeah, we can't have open bulb like that. Can't have no white light placing your red label. It's easy fix. I'll show you how to do it. Probably do it in about 5 seconds. You know, Jack. Your driver's license, your son?
I do not have a copy of my license.
Okay. Are you suspended?
No.
Bro.
No. I have my license. I have my insurance and registration. I didn't know that the open bulb one was.
Yeah, well, see, if you look at it, it's the same thing as having a tail light that's open. So why you got it? Who's David Bramlett? He's still alive?
I mean, I believe so. His granddaughter let me borrow the truck.
I don't think he's still alive, is he?
I mean, I don't know really, but I know he's Sabrina's friend.
What's your name?
Corner.
Good.
Since we've already watched the body camera, we're gonna skip this part where they see the body camera again, because it's the same body camera we watched. So let's go back around here. There you go.
Officer Brown, is that your body count on the night? Question.
That is my body count that night.
And everything that we saw on there is a true and accurate representation of what occurred.
Correct, everything's true and accurate representation. Try to stop that night.
And the money that you're counting at the end, where did you get that money?
Come off Jacqueline's person.
And could you tell us where did you locate the needles in relation to the drugs?
The needles were in the same container that the drugs was in.
No further questions.
You wish to make this an exhibit,
Oh, yes, yes, please.
make it exhibit 3.
Yes, sir. I'll start in the flash right now.
All right. Mr. Baker, you may cross-examine.
When you first saw Mr. Lynn, and you'd ask him to get his ID out, there didn't appear to me to be any scales there. He gets up and all this. Where were the scales at that point?
I don't know where they were because I couldn't see them.
Well, it was pretty obvious. He reached up. You know how it is when you try to get something out of your back pocket when you're in a car. I mean, stuff in your lap's not going to stay there. I don't notice one on the video. Did you notice where those scales were?
I didn't see him in the video, but he had a hoodie on that had big pockets in the front, which most of us that have wore hoodies know stuff falls out of pockets and something around.
Hold on, that's speculation. You don't know that, do you?
I have worn a hoodie myself. It's all around my hoodie. So
What I'm saying is, do you have any proof Mr. Lynn had those scales in the hoodie, or are you just making that up?
no, I just seen them fall off his lap.
Okay. So, if you would, don't embellish the testimony. Now, you wrote in your report, when Mr. Lynn exits the vehicle, a digital set of scales fell and hit the ground, correct?
I did.
All right. You didn't say anything about it being in his lap, correct?
I believe it's in the warrant that they were in his lap.
But it's not in your incident
But it's
report.
not in the incident report.
And then when the K-9 officer approached, said we don't need to search because what you told him was the scales fell out of the truck and hit the ground, correct?
Correct.
All right. Now that would be, I'm trying to figure out where the discrepancy is because that's what you said, you know, and I know it's been 5 years since this happened, so everybody's memory kind of fades over time. But, you know, you said on the video twice that, hey, it fell out of the truck. It's in the incident report, and then you go back to the warrant, and it said it was in the thing. I'm trying to figure out why the discrepancy is. Either it's, well, I just didn't remember it right, or
It was dark. What it looked like happened to me was it fell out of his lap, out of the truck, onto the road.
okay. But what I'm getting at is we don't know that. That's what we assume happened from the way it was positioned.
Yes.
Okay, now that's what I'm getting. All right, so, and then when you were talking to Miss Varda, you know what a Freudian slip is. When you ask her, is anything illegal in the car, and her first answer was yes. Does that indicate that she's probably lying at that point?
That just made me think that there's something going on.
So you told the officer, she first told me, yes, there was something in the car.
She did.
All right, and what you told him that was the reason too, that you were suspicious that she might have something in the car.
Yes, absolutely.
All right, and then you also confronted her too about, in fact, I think you said originally, hey, didn't I arrest you twice last week or something for, I guess, drug charge, but I guess it was once. Is that correct?
She had been arrested with someone else for drugs prior to that.
And I don't know, was it the same vehicle?
I'm not sure. I had just received information that there was drugs going on amongst that whole group of people.
All right, now that syringe kit or whatever they call it, I don't know what they call it, had all the syringes in it. You may not even remember. I know it's been a lot of years. Were those used syringes? Have they been used?
I don't remember if they were used or not. I didn't know. Like, it's a biohazard. I'm not going to sit there and really analyze a needle that might have blood or might not have blood on it. They're disposed of.
It's only biohazard if they've been used.
Well, we don't know that.
Okay, so I didn't know what you know. Right, but that, I guess we can all agree, needles are indicative of I'm using some drugs. Right. So we're good there. All right, now, I saw when you turned, I guess right there before you get to the church, you turn left. Did you see the car prior to that?
I believe so. Something caught my eye there. I don't know if it was the light originally not working properly in the turn. I'm not 100% sure what initially caught my attention. This 5 years ago.
Right.
A truck driving away after midnight catches your attention.
All right, what I'm getting at is that's really your first encounter when you turned and, hey, the tail light's not working, I'm gonna stop this car.
Yes, that was
Okay.
my first encounter with that vehicle.
All right, now, the point, I think it's 0.47 grams or something, was that what came out of the boot, Mr. Lynn's boot?
Yes, a 0.47 grams came out of his boot just prior to transferring to jail.
Okay. And the digital scales, they happen to be sent off for latent prints or anything?
They weren't sent off for latent prints.
All right, and something was found behind the seat. You don't recall what that was?
There was nothing collected evidential behind the seat. I think there was another one in kits that was empty. That's what Ross found.
Yeah, because
that's why I asked him why are they using those now to put stuff in.
Yeah, because I couldn't figure it. I thought that's where you found something. I couldn't figure out what it was. All right, and something. You had said something on the video too that kind of struck my attention. You said it's an awful, which Ms. Gardner, it's an awful coincidence. And I guess you stopped her twice and maybe have drugs in the car both times. What would that tell you?
But the information that with them being involved in drugs was accurate.
Well, Ms. Gardner would be the common denominator, would she not?
Well, I think it's a whole circle of common denominators. I don't know that there was one common denominator.
Well, she was there both times, wasn't she?
She was.
Mr. Lynn wasn't there the other time, was he?
I have no idea. That wasn't my area.
Okay. And you also said she's good at playing dumb. Your words, not mine.
She was. I don't know if she was good at it, but she was.
All right, just may have a minute.
Right. Ladies and gentlemen, I've been handed a question by one of the jurors. So as I instructed you, I'll have to have you go across to the jury room while I address this issue with the lawyers on the record, and then we'll bring you back as soon as we can.
And we get to see the jurors again. It's rather. Yeah, the old. Yeah, I know. Oh. Let's see what is. I like when jury can ask questions. It gives us like
Question that
an
was
idea.
handed to me is, do normal users need scales for their own high?
Answer that unless it comes up in proof.
Do what?
I don't know that we could answer that for them unless it comes out in proof.
Question is, that the jurors want to know. And there's nothing that would prohibit that question being asked. Whether he can answer it or not is another matter.
One of us asked them in the film.
I'm okay to ask Dr. Brownie or redirect. I believe.
Well, let's ask it right now while the jury's out of the room. And I'm not going to, I'll preface it this way. The jurors had a question as to whether or not a normal user, assuming user of drugs, would need a scales for their own high.
So from my experience, I've never seen a meth user carry their own scales for their own high. It is something I've seen with marijuana users to make sure they're getting the right amount of weight though. And they do that.
I think that's a legitimate, appropriate answer to the question. So we'll bring them back. Do you want to ask that question in general? Oh, well, let's let Mr. Baker ask it since he was still questioning. Bring the jury back. Okay. All right.
His advisor just said turn the camera off when the jury is coming in because he's showing. They just said it. I like the hot mic moments. I absolutely love it. I think it makes the whole trial. I think if it's that little break of sometimes such a heavy subject that we talk. But I really like that one.
Because this sits down too low.
I love this one, and I love a good hot mic moment. You guys know.
Ladies and gentlemen, the question that was handed to me by one of the jurors was whether or not I'm going to allow. I looked at it over the record with on the record with the lawyers, and we discussed it. And it's my belief that it is a legitimate question. So Mr. Baker has said he will ask that question. So
we're going to get to the scales. In your experience, or however best you can answer this, do normal people, drug users, have scales?
From my experience, normal methamphetamine users do not have scales, particularly purchasing a half gram or less. You can tell that pretty easily when it's half gram. They don't weigh it.
Right. Also, that's anecdotal evidence, though, correct?
Correct.
So that's just your experience. It doesn't mean it doesn't happen, correct?
That is correct.
You haven't seen anybody struck by lightning, have you?
I have not.
It does happen, correct?
It does happen.
So you can't discount the possibility just because I haven't personally experienced that.
I cannot discount the possibility.
I can pretty much assure you nobody in here has hit the lottery, but we've probably seen it happen, have we not?
We have.
Although we probably all like to hit the lottery. We didn't. Okay, now, the other person, and you may not know Ms. Garner said somebody else was her boyfriend. You know who that was?
No, I just remember at the end of the video, she said that she has, whenever I asked her about having smoked drugs again, she said she doesn't have good taste in man or something, is what she said at the end.
Now, you watched, well, I mean, you observed Mr. Lynn face to face, right? And plus the video. It made him pretty high. Is that your assumption?
That is my assumption, that he was probably under influence or had been under influence for several days of that.
Okay. So yes, I don't know. That syringe kit, do you think that was Mr. Lynn's syringe kit?
If you're asking me for my thoughts, I would like to give you that opinion on it.
Well, let me rephrase. Do we have anything to indicate whose syringes they were or who had used them? Do we have anything that would indicate whose they were?
The only thing we had was they were in the door next to him where he was sitting.
Okay. And I guess it would have been helpful if we would have kept those. Could we have sent those all? We could have sent them off for DNA testing. Could we, if they've been used?
Probably not if it's not involved in a something more serious, I might say. I don't know. The DA would have to request that for the TBI.
Well, the test is what, right? You can run DNA on blood.
Right, but they could have been tested. That's just not a common practice.
Judge, me have a moment.
No.
Okay. Outside of weight, you charged him basically on weight, correct?
I charged him on the weight and the intent.
Well, tell me what the intent was. Who was he going to sell to?
Anyone in society that was looking to get high.
Is that right? How do you know that?
That's the type of people that buy drugs are the ones looking to get high.
Well, that's conjecture, is it not? That's your opinion.
Well, that is my opinion.
Remember John Z. DeLorean? Do you remember him?
I do not.
You're not familiar with FBI cocaine busting, Mr. DeLorean?
I'm not.
I'm going to object to relevance.
So the answer we didn't know, so it's not going.
Suspend the objection. It's not relevant.
All right. So where did Mr. Lynn get these drugs?
I'd like to know. We would have made another arrest.
When did they get in the vehicle?
I have no idea.
Who put them where?
To me, it appears Lynn put them in the passenger side door next to him.
When?
Don't know.
Who else was with him?
Samantha Gardner, the driver of the vehicle.
And so she would be the only one that would know, correct?
I don't know if she would know or not because I don't know if she was the one who got it.
She would be in one better position to answer these questions, would she not?
I'm not sure.
Well, would she be the better witness of what occurred prior to that stop?
She said she had no idea the drugs were in there in the video.
Are you going to answer my question or tell me what she said?
Would you ask?
She would be the better witness to ask these questions, correct?
I can only witness to what I seen. If you have a question about where it come from, she was the driver. That's who you should probably ask.
All right, so she would be the better witness, correct? So you don't know, well, when was Mr. Lynn going to sell it? This drugs, you said he had intent to sell. When was he going to sell it?
Sure, just when he got the first opportunity or someone was on it. His phone was going off during the traffic stop, so.
How many little plastic baggies did he have in there to sort it?
I did not see any bags in there. The vehicle was very, very dirty and trashed, and it's easy to hide plastic bags in a vehicle like that.
So you're going to tell me because you did an in-thorough search, it's now Mr. Lynn's guilt?
I would tell you it's very possible I missed baggies in a vehicle like that.
Well, so you missed important critical evidence to prove intent.
It's possible I could have.
Well, that's reasonable doubt. And
I don't think it's reasonable doubt. I just think it's another piece I didn't see that was in there. I didn't see it, so.
if a man would have had, let's see, how many hits did you say that was? 200 or wherever it was? Had 200 baggies to sell all this stuff?
Not ideal. He could have been selling that half ounce just like it was.
Or he could have just bought a half ounce for personal use, could he?
Could have.
Just as possible.
It is.
No further questions.
McLeod?
Officer Browning, would you agree that pretty much anything's possible?
Anything is possible.
If we're going to engage in speculation, we can do that all day, correct?
Correct.
What's important here is baggies are not the only thing you need to show intent, are they?
They are not.
And again, not to belabor the point, but what were the things that made you believe there was intent to sell?
The amount of drugs in there and the digital scales all together.
And again, in your training and experience, is it customary for individuals who are only using to carry that much meth?
Jackson, call speculation. There's no way he can answer for every person on the planet.
Well, Your Honor, I would respond by saying that Mr. Baker sort of opened the door to that.
Repeat your
Furthermore,
question to make sure I'm understanding.
I said in his training and experience, is it customary for users to have that amount of meth? Which I believe I've already asked that question.
It's already been asked and answered. Overruled.
You want me to answer?
No, I think he said this before.
Okay, gotcha.
So it was a combination of things that led you to charge him with that charge of resale, correct?
That's correct.
Do you have to have baggies present to make that charge?
I do not.
Is it possible that he could have been selling the drugs as a whole?
Objection, calls for speculation and a hypothetical.
Your Honor, if I could respond, Mr. Baker opened the door to the line of questioning that he asked Officer Browning in his cross, if it's possible that he could have been using for personal use. He opened that door.
I agree. The door has been opened by Mr. Baker's line of questioning regarding asking a witness to speculate about all different types of possibilities. So overrule the objection.
Possible he could have been selling those drugs as a whole.
It's possible that those drugs are being sold as whole, and the kit that the drugs were in, a lot of drug dealers usually have extra needles, and they sell those needles as they sell drugs, so there's a market for them as well.
And he did have extra needles, correct?
And he did have extra needles.
So it's possible that he could have been selling it as a whole. It's possible that he could have been selling it individually.
It is.
And as you testified, it's possible he could have been using it all himself.
Absolutely.
But based on what you know and your training and experience, you did not believe that the latter was what was going on here.
Correct.
As far as the questioning about Miss Garner, she told you there was nothing in the vehicle, correct?
She did. That she knew of. When I asked her for something illegal, she suggested, she said no, but she wasn't aware of anything illegal.
You could have charged her as well, correct?
I could have.
Objection to relevance.
Overruled.
Why did you choose not to charge her?
Because all the items found were within the direct vicinity of Jack.
Mr. Lynn?
Mr. Lynn, yes.
In his direct vicinity, what do you mean?
Well, it appeared they fell out of his lap out of the truck onto the ground, the scales, and then the kit that had the drugs and the needles in was in the passenger side door pocket right next to where he was sitting.
Within his reach?
Within his reach.
Do you take that into consideration when making charges?
I do.
And also, Mr. Lynn took responsibility for everything, correct?
Mr. Lynn did take responsibility. If you've seen the video, you'll see where he acknowledged that she didn't know they were in there.
She said she didn't know, and he said she didn't know.
That's correct.
And everything was found near him.
Yes.
Okay. And that is the reason why she was not charged as well.
That's the reason she was not charged.
All right, no further questions.
Any recross?
Now, officer, you're saying that just basically because you don't believe it, all these other things couldn't happen, correct? It must be selling drugs, correct?
It is my belief that he was selling drugs.
All right, well, let's go through that. I got syringes, which is indicated to be used, correct?
There were syringes in the kit.
I got 12 grams of some kind of drug, correct?
There was 12 grams of methamphetamine.
I got to have some way to dose that out if I'm going to use it, so I'm going to have to weigh it, correct?
I don't know if they dose their weight out before they chew. I think they usually get a rock off of it if they're getting high out of the big bag.
Well, how do you know that? Have you been doing a lot of meth?
I've not been through it myself, but on a personal level, I've experienced it with family.
Would you like to know how much meth you were shooting or just risk overdose?
Sometimes they always risk the overdose.
All right. Which one would you do?
I wouldn't do meth.
All right. And you wouldn't want to overdose either, would you?
I wouldn't do meth.
All right. You can evade the question all you want. I mean, it's not cute. You're trying to convict Mr. Lynn here, but you won't answer the questions.
I'm not going to agree that I would do drugs.
All right. But you would agree if someone was doing drugs, it's probably not in their best interest to overdose by not knowing how much they're injecting, correct?
Correct. It is not in their best interest.
It would be a good idea to have a scale, wouldn't it?
It would.
No further questions.
Redirect.
Briefly. In your personal experience, do drug users and drug dealers act in their best interest?
Never.
I'm going to object. There's no way anybody can answer that question.
Again, I would respond, Your Honor, if Mr. Baker opened the door to that by asking him how a drug user would act in their own best interest, and would they not? By using scales. So I'm just simply following up.
You asked the question, Mr. Baker, about his opinion about whether a drug addict or a drug user would or would not act in their own best interest. All those questions were not objected to by the state, and the state now has the opportunity to follow up on those questions.
So I repeat the question. Thank you. Do they act in their best interest?
No, they do not.
In fact, you could say they act very much against their self-interest. Do they not?
They definitely act against their self-interest.
In your experience as a police officer, do a lot of people, individuals who are using drugs, do they seek out that high? They might send it into overdose.
They do. They want to see how far they push it before they do overdose.
In fact, we have a lot of overdoses in this county from that, don't we?
We have a lot.
Would it be more likely that a dealer would have scales in order to sell his product as opposed to a user having to make sure they're being safe?
Yes.
Thank you, Judge. No further questions.
Thank you. Any recross?
No, I'm not gonna be still.
Thank you, sir. You may sit down and have a seat. State may call your next witness.
Thank you, Judge. State will call former Officer Ross. 16.
You'll step right up here, please, sir. Ask you to raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Thank you. Have a seat, please.
You may ask.
Officer Ross, can you state your full name for me, please?
David Owen Ross.
Mr. Ross, were you working for the Waverly Police Department back in March of 2020?
Yes, ma'am.
And can you tell us what your involvement was on that night of this traffic stop with Mr. Lynn?
Officer Brandon had made a traffic stop and he requested me to come up to the location because I had the canine dog at the time. And the intention was for me to do a free air sniff with the dog around the vehicle.
You didn't have to do that, though, did you?
I did not.
Were you there on the scene when Mr. Lynn stepped out of the vehicle?
I believe it was.
Did you see everything that happened or part of it?
Didn't see everything.
Okay.
I think as I pulled up, Officer Brandon said that he was going to use a dog, but a set of digital scales that fell out on the ground. So we were going to do a probable cause search.
Okay. Did you assist with the search of the vehicle?
I did.
Okay. Do you recall if anything was found in the vehicle?
I was on the driver's side. Officer Brandon was on the passenger side, and we had been searching for a little bit. And my memory served me right. He pulled out what looked like some kind of maybe glass container, like you put glasses in or some kind of container. He opened it up and I saw drugs in it.
Did you find anything on your side of the vehicle?
I did not.
So the driver's side, there was nothing there.
Find it.
Did you do anything else with that, or was it mostly Officer Brown?
It was Officer Browning.
All right. Well, I don't think I have any further questions.
Baker?
Officer Ross, do you know how that drugs got in the vehicle?
I do not.
No further questions, sir.
Thank you, officer. You may step down. Call your next witness.
Dr. Statement called Deputy Jonathan Porter.
Deputy, you come right around here, please. Raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth to help you God.
I swear.
Thanks. Have a seat, please.
Deputy Porter, could you state your full name for me, please?
Jonathan Porter.
You work for the Humphreys County Sheriff's Office?
Yes, ma'am.
And what is your current position there?
I'm Sergeant over the SRO division.
I'll call you Sergeant now.
Yes, ma'am.
So, back in March of 2020, where were you employed?
Waverly Police Department.
And what was your job title, or what were you doing there?
I was detective and I was also over evidence of the police department.
You were the evidence custodian?
Yes, ma'am.
And were you in charge of the evidence that was collected from this traffic stop?
Yes, ma'am.
Okay. Your may I approach the witness? Do you recognize that form, sir?
Yes, I do.
What is that?
This is a TBI submittal form. Submit the TBI to find out the contents of the evidence.
Okay, so you would have filled out and signed this form, correct?
Yes, I did sign it.
And did you put that form with the evidence when you took it to the TBI?
Yes, ma'am.
Okay. And you did take the drugs that were seized to TBI for analysis, correct?
Yes, ma'am. I dropped it off with this form.
Okay. Do you recall about when you would have done that?
I would have to see the evidence sheet to tell you the exact date.
But you did take it to the TBI.
Yes, ma'am. I didn't sign it unless I dropped it off first.
And can you tell us, when the drugs are put in evidence, how are they secured and protected during that time?
Secured by a door. And behind that door, there's several storage lockers within the evidence room. There's also locked, so it's double locked, if you will.
No one has access to it but you.
No one had access to the storage compartments but me, and no one had access to the evidence room but me and Chief Gillespie. So Chief Gillespie has access to the door to get in the room, but not the actual lock.
Okay. And once the TBI had finished analyzing these drugs, they would have sent them back?
Yeah, so I made trips up periodically every quarter or less, depending on how much evidence we were taking in and what needed to go. And as I dropped off new evidence, they would give me back whatever they had completed, and I would bring it back and put it back in.
So the accurate way is that you would also pick it up from TBI?
That's right.
Okay. So you had it, the only time you didn't have your hands on it was when it was at the TBI,
That's
their
correct.
storage facility.
That's correct.
And when you brought it back, you put it back in evidence.
Put it back in evidence.
And it's been here this entire time until
Yes,
today? Okay. No further questions?
Mr. Baker, you have any questions? Good. Was this made an exhibit general? Was this an exhibit?
I'm sorry, yes, you are. I think I did it through.
Number 4,
Oh,
the drive is.
yes.
Exhibit 4.
No further questions. Several.
Thank you, sir. You may sit down. You may call your next witness. Anybody need a break over here? Are we okay? All right.
Your Honor, the state would call TBI agent John Scott.
Let me bring to your attention, I was handed a note that one of the jurors says that he had a personal relationship or acquaintance with Officer Fortner, but I don't believe that that presents any problem whatsoever, so. Step forward, sir, and raise your right hand and face our clerk to be sworn in.
Do you solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Have a seat, please.
Good morning, Mr. Scott.
Good morning.
Or I guess I should say afternoon, shouldn't I?
Sure.
Could you state your full name for us, please?
John Scott Jr.,
And where are you currently employed, sir?
Tennessee Bureau of Investigation, Nashville Crime Laboratory.
And what is your job description? What do you do here?
I'm a special agent forensic scientist in the Drug Identification Unit. And so basically what that means is agencies around the state of Tennessee will send substances into our lab that I test to see if there's anything that's in the Tennessee code that's a controlled substance.
And you are trained and qualified to do this, correct?
Yes, ma'am. I have a bachelor's degree majoring in chemistry from Kentucky Wesleyan College. I also have a master's degree majoring in organic chemistry from the University of Kentucky. I've attended DEA seminars on drug identification, successfully passed and completed the Tennessee Bureau training program on the drug identification. And I attend some seminars in the field as funding is available.
So you have continuing education that you do.
Yes, ma'am.
Your Honor, at this point, I'd like to pass up Mr. Scott's CV
All right.
as exhibit 5.
Exhibit 5, you want him to identify it?
We stipulate an expert forensic testing. I mean, you don't really have to go through the whole show, but I mean, he's qualified.
Well, I wasn't going to ask any more questions. I was just going to put that in there in case the jury wanted to look at it.
Ladies and gentlemen, the defense is stipulating that Agent Strong is a qualified expert. Agent Stock is a qualified expert in the field that he's testified about, so he will be considered by you as an expert witness. And if you'll hand me your CV, we'll go ahead and make that an exhibit. Thank you. I kept calling you Stock and Strong, but it's Scott, so yes. Thank you.
And as part of your job duties, did you test the drugs related to Mr. Jeremy Lynn?
I believe that's the name that's on the request form. Yes, ma'am.
Okay. And you're a map person.
You may.
Sir, can you identify that document, please?
I believe to be an accurate copy of the lab report that I generated pertaining to this case.
Okay. And can you tell us how you go about testing the drugs that you receive?
Sure. So once I get the drugs from our vault, I take it back to my little work area and I start noting how it's packaged. And that's the outer package, making sure everything's sealed. And then once the outer package is noted, cut into it, see what kind of inner packaging and what kind of substance that we may have.
And on the lab report, we put a description, and that's basically what my eye is, what I see, what it looks like to me. So that's a very general catch-all type description. And so, you know, that's tablets or crystalline substance or powders typically are main three things, along with plant material, I guess, and so forth, that we'll get into the lab. Once I do all that, then I dump the substance out onto a weigh boat that I have previously zeroed out, to put it on my scale or my balance to get a weight of just the substance. And I'll record that weight. Then I'll take 2 samples, which I'll perform instrumental analysis on to see what substance may be present.
And you had 3 bags, correct?
I did have 3 outer bags in this case, yes, ma'am.
And can you tell us how much methamphetamine you tested in bag 001-8?
So in the first bag, I had a weight of 12.02 grams, and it did in fact have methamphetamine that's being present.
Okay. Could you look at that number again? It's 12.08. Okay, 08. All right. And bag number 2, how much
again, the crystalline substance is being present, identified methamphetamine, and it weighed 0.48 grams.
And in the third bag, what did you find?
This was described as a powder, and I found 2 substances there, heroin, which is a Schedule 1, and cocaine. It's also a Schedule 2, like methamphetamine, and that weighed 0.74 grams.
And you were able to test that and confirm that that's in fact what those drugs were?
Yes, ma'am. I had 2 independent samples on 2 different instruments, and both of them showed both of those drugs as being present.
No further questions.
And
I'm sorry, Judge? Oh, yes, I'm sorry, that would be exhibit 6. I apologize.
that's it.
6, yes, sir.
Mr. Baker, you may cross-examine.
No questions?
Thank you, Agent. You may step down.
Thank you.
And we'll release you from your subpoena so you can go about your business.
Thank you.
General McLeod, you may call your next witness.
Sir, the state has no further proof.
State has no further proof. Mr. Baker, do you wish to,
Judge, I'd like to take a break and then make a motion while the jury's out.
all right, ladies and gentlemen, we'll take our afternoon recess since we got an earlier start. Let's make it about 15 minutes. I'll have to take something up while you're outside the courtroom.
All right, state has arrested. You know, the poll is still 100% guilty with 8 votes, which is great. So everyone thinks he's guilty. But what do you think? Do you think the state now has proven? Has it not? Let me know. Yeah, I think he's gonna get guilty. There's no way. I don't think. I mean, come on. But you know, crazier things have happened.
Baker?
Judge, I'd like to make a judgment for motion of acquittal.
A motion for judgment of acquittal or a judgment of the motion?
Or dismissal on the possession with intent to sale. The record is devoid of actual evidence. What you have here is testimony based on training and experience, which is not proof. That is opinion testimony, any way you cut it. And it's anecdotal opinion testimony based clearly the officer did it. So it's not proof. It also, the testimony one is equally likely. It's equally as probable proof of the personal use. I move to dismiss the felony charge and charge the jury only with simple possession.
Bill McLeod?
Well, the state's response is that that's a question of fact for the jury to determine. They're going to make a determination whether he possesses drugs for resale or whether he was using it for his own use. And we feel that's a question for the jury.
Well, as the instructions to the jury at the outset of this case indicated, there are 2 types of evidence. There's direct evidence and there's circumstantial evidence. Circumstantial evidence is that evidence which gives us clues about particular things. And this court is of the opinion that the circumstantial evidence in this case of the video showing that the defendant rose from the car or from the truck and that the scales fell from his lap and that in that door to the car was a quantity of drugs that is in excess of what the normal user, according to the testimony of the experience of the officer. Therefore, your motion for judgment of acquittal as to those counts regarding the possession for resale is respectfully overruled.
Judge, I'd ask for a special jury charge, and I'll write it into the record as the appeals requires. I would like the jury to be charged that this training and experience opinion testimony of an officer is not proof and only can be used to guide you in evaluating the truth.
There's an expert testimony charge that's already contained within the final charge, and you can make your argument according to that.
That's only applies. The only one that's been
And you want to specifically designate the officer's testimony, but he was, as you know, expert testimony can be qualified based not only on training, on education, but on training and experience, correct? That is the law.
It is.
And the law is that if the court finds that his training and experience allowed him to make that opinion or make that statement or that testimony, then that would fall under the definition of expert testimony, which is in, I think it's in the charge. Did we include that in the charge?
That's what I'm getting at is, there's the law. I think this is a pretty accurate reflection of the law. Opinion testimony of an expert is not proof. It is used to assist the jury in evaluating the proof. And that's all I was, but I wanted it specific to the officer.
I know you want it specific to the officer, but I am not going to make it. We don't make that instruction specifically to say, this witness testified as an expert. Now, here's what I want you to know about that. We don't do that. We give the general expert witness testimony charge to the jurors. And here's what it says. You have heard the jury trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state opinions concerning such matters and give reasons for their testimony. The next page. Merely because an expert witness has expressed an opinion does not mean, however, you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment as to whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. That is my opinion, that addresses all of the issues that you have. I will not add a provision that this particular witness's testimony is to be singled out and identified as that. We've given an expert testimony a charge, and I think that is sufficient.
So I can't argue that to the jury.
Argue it to the jury, certainly.
Okay, sounds good.
Anything else?
Not for me, Judge.
All right, then we'll recess. Are you going to make your opening statement are you going to put on any proof? I guess would be the question. All right, is your client, at this point, is your client likely to testify, or are you going to reserve that issue?
We're leaning no, but it depends on what the person.
So we just need to do the moment waiver. Just let me know as soon as you know, and we'll do that. I just don't want to have to send the jury out if I don't have to.
Exactly.
We'll stand in recess for about another 10 minutes to resume.
All right. So while we skip, what do you guys think? Do you think that the state has proven or not? And do you think that the defendant will testify? I mean, I don't think so.
Jennifer, do you remember
Hot mic.
Elliot? Shannon or something? Cheatham County.
I don't
Shannon,
think
Elliot.
Jennifer remembers anything. Let's just
Mother's
skip.
calling me. She wants some transcript.
Judge is back.
Bring the jury in. All right. The state has rested their proof. Does the defense wish to offer any proof?
We do, Judge.
All right, call your first witness.
Judge, I'd call Ms. Samantha Garner. Judge, will you approach for a minute?
You may.
You do know. Can they hear me?
Yes.
Oh, well, like I said.
I can.
Yeah, we all can hear you. Yes. Yeah. Sadly, we are not going to be privy of that, but yes, we all can hear you, sir. Judge, please unmute yourself. We have two judges to judge. Nice. We have a very good view of the judge there. Judge, please unmute. Please. I hope the judge doesn't forget to unmute, because that would be so bad right now. If it did. Oh man, he forgot to unmute. Or can you guys hear? I can't hear the court. Hang on. But I know my headphones have been having an issue. Judge, please. Oh, the judge just forgot to
And
turn.
I
Oh,
pretty
there you
much
go.
started him out of my truck. And I was headed back into Waverly, and Jack called me, said he needed a ride.
Okay. How long was that before you were stopped by the Waverly Police Department?
Not long at all.
Okay.
Like
Where
they pulled me over. Like he'd been in the car 5 minutes.
Okay. Where'd you pick him up at?
Somewhere his mama had been staying in town, like right in town.
Okay. How close was it to? Is it like the next street over from where you were stopped, or the ballpark where it's at?
I mean, it was real close to Cooley, I think.
Okay. I don't know where that is.
I don't
It's
really
pretty close to where
remember.
you- Okay.
I know that he wasn't in the truck long at all.
Okay. When he got in the truck, what did he have with him?
Himself,
All right. Did he appear to be under the influence of something when you picked him up?
a little bit, yeah.
Well, let me just ask you. Was he stoned, fried, high?
I'm not real sure.
Well, when you were with him, did he appear to be normal?
I mean, no, I wouldn't say so.
Okay. Was he under the influence of something?
Yeah.
Okay. And now, you remember when you got stopped? And you remember the officer asking Mr. Lynn, he's sitting beside you, to get some identification.
I think so, yeah.
Do you remember that? Do you recall ever seeing a scale in Mr. Lynn's lap?
No,
All right. Were you aware that there was a scale in the vehicle?
no, I was not.
Okay. All right. Who had been in that vehicle prior to that?
You're asking me to,
Before you answer.
ladies and gentlemen, just a second, please. I'm gonna mute you.
We are muted again. Come on, Judge. Really? Let's skip it until we are unmuted again. Let's just skip it.
Waverly, like
There you
probably
go.
10, 15 minutes later, Jack called me.
Oh, and what did he want?
All right.
Okay. And obviously, is Mr. Lynn a user? Is he a drug user?
Yeah,
Okay.
yes.
All right. And you initially told the officer that when he asked you, is anything illegal in the car, you said yes. But then you changed the answer. Did you lie then when you changed the answer?
I might have been.
All right. So you knew that there was drugs in the vehicle?
Yeah.
Whose drugs did you know was in there?
Joshua.
All right. You had been previously, I guess, arrested the previous week with possession of drugs?
Yes.
Is it related to Joshua also? Or somebody
No,
else?
it was somebody else.
Okay. But the scale was not Mr. Lynn's, the little pack was not his?
No.
Okay. No further questions.
Ladies and gentlemen, step across the hallway, please.
This is starting to be like a yo-yo. Mute, jury stepping off, and we still can see the jury judge, but okay. Why did they walk with their hands behind their back? The jurors, you're not in prison or in jail. You don't have to do that, I don't think.
My concern is that this witness has potentially presented herself in a position where she may be charged in this case with constructive possession of the drugs that were in the car, because she told the officers at the scene that she did not know any drugs were in the truck. Now she says there were drugs, and she knew there were drugs in the truck at the time, which under the laws of constructive possession means that she could be charged with possession of these felony amounts of drugs. And I think she's entitled to know that she's subjecting herself under your questioning to the possibility of being prosecuted for felony drug possession. So I'm going to instruct her that she has the right to remain silent under the Fifth Amendment, and that she needs to understand she has the right to refuse to answer questions. Ma'am, when we listen to and watch the video of this case, and you have already testified that you were asked if there were any drugs, to your knowledge, in that truck. You stated to the officer on the scene, according to the video that we watched, that no, you did not know. Now and for that reason, the defendant also stated at that time that you didn't know anything about the drugs. Well, you be quiet. Now you're testifying that you did know there were drugs in the truck, and what I want you to understand is that potentially presents you in a situation where you can be charged with felony possession of drugs because you knew they were in your truck while you were driving around. Constructive possession means that you knew they were there. You might not have physically had them in your possession, but they were in your control, under your control, and therefore you could be charged. So therefore, if you're going to be asked questions on cross-examination by the state, you have the right to refuse to answer those questions under the Fifth Amendment of the Constitution, which states that you don't have to testify and incriminate yourself, but it's up to you to invoke that privilege against self-incrimination. Now, by refusing to answer the question, what you're stating is that you are refusing to answer the question on the grounds that your answer might tend to incriminate you in a criminal act. You understand that?
Yes.
And you understand all the rights that I've explained to you.
Yes.
All right. Then we'll bring the jury back and we'll let the state cross-examine.
Oh, she did a dumb thing. Why did, like, it's not that she could not agree or not if she was subpoenaed, but she literally can go to prison over this for testifying and putting, oh my days. This is just why I love this. See, this is why I like little trials sometimes. You get this good spiciness that you don't see sometimes in other ones. I like it.
So, McLeod, you make a question.
Thank you, Judge. Ms. Garner, is it your testimony that you're just a user, or you were a user?
Yes.
Okay. Are you not currently on probation for felony drug charges?
Yes.
Possession of meth for sale?
I'm in rehab, yes.
That wasn't my question. My question is, you're on probation for felony selling meth, right? So you pled guilty to being a meth seller?
I guess I did, yeah.
Okay. So you're not just a user, are you?
Yeah, I am just a user.
But you're on probation for sale of meth, correct?
I'm gonna go ahead and plead the fifth.
Your Honor, that case has already been determined. She would be incriminating herself under that case.
If it's a case that's already been disposed of, that's not an incrimination of yourself, so you cannot plead the fifth on that particular situation.
Okay. As relates to the charge that you're on probation for, that was for felony sale of meth, correct?
Yes.
Okay.
It was personal use though.
Okay. But you pled.
Yeah, I did plead to it.
And that was 8 years of probation, right?
Yes, ma'am.
As opposed to 1129. Okay. Why didn't you tell the officer at the scene that it was Joshua Vetter's meth?
Now can I plead the fifth?
Yes. She is pleading the fifth. What that means, ladies and gentlemen, is that she's invoking her right against self-incrimination under the Fifth Amendment of the Constitution. You must state that you refuse and you decline to answer the question on the basis of the Fifth Amendment right. So, is that what you're stating?
Yes, sir.
You testified earlier you knew the meth was in the truck, right?
I'm gonna plead the fifth.
Would you agree that you told the officer on the scene that there was nothing in the truck?
You have to invoke the Fifth Amendment right on each question that you refuse to answer.
Invoke the Fifth Amendment right.
So you're not going to answer as to what you told the officer on the scene? Okay. Are you lying then, or are you lying now?
I'm not lying now.
You sure you're not lying now just to try to keep Mr. Lynn from being convicted?
I'm absolutely sure.
Why should we believe you?
Well, because I was there, I had first-hand witness.
But I'm seeing in the body cam that we watched before you're testifying now, you told the officer there was nothing there.
Well, I'm not going to deny the fact that I was on drugs when that happened.
Do you believe that being on drugs gives you an excuse to lie to police?
I believe that it does not, it changes how you act, yes.
Did you understand the question from the officer that night?
I don't really remember.
Allow me to refresh your memory. Your Honor, I'd like to play the body cam part of it. I think that's it.
I turned it off because your calendar was up there and I didn't.
You're gonna have to go through the same process again.
Or maybe not, because I was hurt just sitting.
Ms. Garner, did Joshua Vetter put the meth that was found in Mr. Lynn's shoe in his food for him?
I don't know the answer to that question.
What did Mr. Vetter put his meth in that was in the truck? What was it in?
It was probably in a baggie.
It was in a baggie. Okay. So the meth that was in the truck that the police found that night was in a baggie?
I believe so. I'm not sure. I was really mad at him and I just kicked him out of my truck.
But you didn't tell him to take his dope. Sorry, did you answer that question? Did you tell Mr. Vetter to take himself out of the truck?
I didn't talk to him. We just had bad words and I wasn't thinking, I just wanted him out of the truck.
So again, before we watch this, the meth that was found in the truck, do you know where Mr. Vedder put it?
I don't remember.
Do you know if it was in anything besides the baggie or if it was just in the bags?
I don't know.
Step over here, please.
McLeod, we're gonna,
Oh, I'm sorry. I'm so sorry.
what's a Diddy trial?
No.
Perfect. Well, you just want. Don't worry about it right now.
Well, I was just trying to get off
The cover probably screws off and that bubble come out.
All right.
What? Who took your license?
Grant Hubble, he lost it.
What are you taking for?
Me and my boyfriend were pulled over a while back, and he's still in jail over it actually.
Who's your boyfriend?
John Stacy. He's my ex-boyfriend now.
Gotcha.
Yeah.
There's no beer in the truck. I smell beer.
Nobody.
There's
I
no
don't drink.
Okay.
I haven't drank in years actually.
Everything legal in this truck?
Yeah. Oh, and I thought you said everything's legal. No, there's nothing legal in the truck.
Are you sure?
Positive.
Are you on probation?
No.
Step over here, please.
Ms. Garner, did you understand what the officer was asking?
I guess I had not. It appears to me that I did not understand the question at first.
But you did after a minute, didn't you?
No, I answered because I thought he was going to say, is there anything, is everything legal?
I understand that. I'm asking you about when you corrected yourself and said, no, there's not. Absolutely not. You knew what you were saying then, didn't you?
Yeah.
So you knew you were lying.
I'm going to go ahead and take a pic.
So you expect us to believe you now? Are you sure Mr. Vedder didn't sell y'all that dope?
I'm going to plead the fifth.
Mr. Vedder sell Mr. Lynn that dope?
No.
He didn't sell it to him?
You gonna play any more of that video? I don't care.
I don't
I'm
think
just-
so. I think the jury has seen it. So essentially your testimony is that you knew the dope was in the vehicle. Mr. Lynn didn't, even though it was found in his immediate vicinity. And we should just all blame Mr. Vedder and let Mr. Lynn go.
Well, I'm just here today to tell the truth about the matter and that the dope was not Jack's.
But you're not telling the truth, are you? You're pleading the fifth, which is your right. You're not telling the truth, are you?
I'm telling the truth.
Just one second. No further questions, Judge.
Make sure you have it redirect.
Are you in rehab now?
Yes, I am.
How long have you been clean?
I've been clean 6 months now.
Do you have any reason to lie now?
No, I don't.
Subjecting yourself to possible legal action?
Yeah.
Correct me if I'm wrong. The only drugs that could have been Mr. Lynn's what was in his boat. He didn't have the other drugs.
Sustained.
Let me rephrase that. You wasn't aware that there was a little bit of drugs in Mr. Lynn's boat, correct?
No.
Okay. So you can't account for that.
No, I can't.
The rest of it you can account for.
Yeah.
No further questions.
You're on the cloud?
Ms. Garner, you testified you're in rehab, correct? You're in rehab because you violated your probation, correct?
Yes.
You tested positive for drugs again. And instead of going to prison for 8 years, you went to rehab.
Yes.
All right, no further questions, Judge.
Mr. Baker, anything further?
No further questions.
Thank you, ma'am. You may step down. You're excused. Mr. Baker, you may call your next witness.
Judge, I think that's going to conclude our proof. I don't know if you want to do the waiver now or.
Ladies and gentlemen, if you'll step across, I've got to take up one matter before we begin the next stage. Do you have a form for Roman? Sure, the entire period. We ready? Bring your client up.
Lynn, state your name for the record, please.
Raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you now give shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Ms. Lynn, if you would state your name for the record, please.
Jeremy Jacqueline.
All right, Ms. Lynn, you know you have an absolute right to testify in your trial, correct?
I do.
You have a right not to testify if you so choose.
I do.
If you so choose not to, the judge is going to instruct the jury here. They can draw no inference of guilt, the fact that you didn't testify. And we've been over your option to testify or not testify.
Yes, sir.
You know that's completely your decision. It's not mine. It's not the judge's. It's not anybody else's. Purely your decision.
Yes, sir.
Have you made a decision whether to testify?
Yes, sir.
What is your decision?
Why not?
All right, I believe he has successfully proven that you'll sign off on the waiver, please, both you and Mr. Baker. All right, and we're ready for me to allow you to have your closing arguments. So bring the jury in and we'll start closing arguments. Well, does the state have any rebuttal proof? I suppose.
Oh, no, yes.
I need to ask you that on the record when the jury's back.
Yes, Judge.
All right, ladies and gentlemen, the defense has rested their proof. Does the state have any rebuttal proof? All right, then you have heard all the evidence that you're going to receive in this case to help you make your decision. So now we move to closing arguments, closing statements. Gentleman McLeod, you may first address the jury.
Thank you. Ladies and gentlemen, I want to start off by thanking you for your attention today, for listening to us and watching the body cam footage and listening to everybody. I just want to kind of summarize what we saw, what we heard. I mean, when we started out this morning, I told you what you were going to see and hear. And we started off with Officer Browning. He testified about his training and experience as a police officer, about this particular incident, about the amount of drugs that he found, and the reason he made the decision to charge Mr. Lynn the way that he did with the possession for sale. He talked about the quantity of meth that was here present in the case. I believe he said anywhere from 100 to 120 hits was what you normally get off that amount of meth. He testified about 7 hits or so off of the heroin/cocaine combo. He testified that there were scales that found needles as well and some cash. And based on those circumstances, he made the decision to charge Mr. Lynn with possession of meth and heroin for resale, as well as possession of drug paraphernalia. You got to watch his body camera footage, which corroborated his statements to you, showed that what he testified to is actually what happened. You saw the scales, or heard the scales rather, fall out of Mr. Lynn's lap or out of the door when it was opened. You heard him talk about that on camera. You saw the drugs on camera, as well as presented as evidence that you can further examine if you choose. After Mr. Browning testified, you heard from Officer Ross, who was brief and he was just there and he helped. You heard from the evidence custodian, who established the procedure for securing drugs, items of that nature, keeping them in a secure, locked location so that no one can tamper with it or mess with it. He testified that he took the drugs to the TBI for testing and retrieved them when the TBI was done. You then heard from the TBI agent, who testified as to his methodology, his training and experience in being able to test drugs as well as determine their load. You heard him testify that based on his expert knowledge and experience about the amount of meth, which is 12.8 grams, the less than half a gram that was found in Mr. Lynn's shoe, and you heard him testify about the heroin and cocaine that he also found. It's the state's position that we have proven our case to you today beyond a reasonable doubt that Mr. Lynn was in fact dealing with those drugs with the intent to sell them. And we would ask that you, the jury, take that into consideration and find Mr. Lynn guilty of both counts of possession of drugs for sale as well as possession of drug paraphernalia. Thank you.
Mr. Baker, you may address the jury.
And I respectfully disagree. I think this case is a classic textbook case of reasonable doubt. Let's go through what the reality is. I've got an officer who stops a car. You saw when he come out down that highway, the minute he saw this car, he made a beeline for it. And the officer testifies, oh, well, when I pulled in to chase you, the taillight wasn't working. You know what was working? The brake light. You know what was working when we pulled over the taillight? That's suspicious. 2, I smell beer in there. That's the next thing he tells Scar. I smell beer. Did you find any beer in there? Not a lick of beer. Beer is suspicious. See what they're doing? I'm building probable cause here just to make an arrest. Neither one of these facts really can be established by what he showed you here. Then the tag light. Oh, no, the tag light's working now. Oh, let me back up and say, oh, we didn't have a cover on. Well, he didn't know that at the point in time he darted down that avenue, because now that the tail light's working, I got to come up with something else. Another suspiciousness. Tell you what else is also suspicious. This Gardner had been arrested the previous week. Now, why was that car being stopped?
Ladies and gentlemen, step across to the hallway, please. Closing argument can argue the inferences and can argue the evidence. You cannot argue the issue of whether or not should have been a suppression motion unless there was, you let me finish. The suppression, unless there should have been a suppression motion. What you're arguing is there was no probable cause to stop that vehicle. And I'm just cautioning you that if you keep going, I'm going to have to instruct this jury that the issue of whether or not there was probable cause to stop this vehicle is an issue that was required by law to be litigated before this trial, and that no such motion to suppress was filed. So I just want you to understand that you're teetering on that edge, and then we'll go from there. I understand you're arguing that there's a conspiracy or whatever you want to argue to charge her, but the question of whether or not there was probable cause for the stop is an issue that you and I both know should have been raised before this trial. And if you argue it to the jury strenuously enough, then the state has a right to ask for an instruction to the jury that that's an issue that should have been raised before trial.
Well, for the record, why we didn't raise it is I think if you look objectively at what, even though the light is working here, there is testimony in the record that says, oh, I've got a shorter electrical problem. So it is reasonable for that to happen. I mean, I don't really know that I even had a legitimate basis for a suppression issue. I mean, we looked at it, but had we thought we had one, we had, but that's not where my argument was going.
Well, whether you did or didn't have the right evidence and so forth is another issue that's not before the court. My only reason for sending the jury out is I was fearing that you were going down the road that I was going to have to instruct the jury on the probable cause for the stop issue. So having explained that to you, you can bring the jury back and you can finish.
Got where I left off.
Mr. McLeod, your battery is running low. Go ahead, Mr. Baker. Ladies and gentlemen, I apologize. There was an issue that I felt like I needed to address, and you should not infer what that issue was. You should not concern yourself about why I sent you across that room, other than the fact that apparently I want you to get a lot of exercise today. So I apologize for that, but we'll let Mr. Baker pick back up. Thank you, Mr. Baker.
All right. So then we have the situation that, sure enough, Ms. Garner was arrested the previous week. So now I've got the person who has known to have been in possession of drugs, and according to the testimony, cross-examination by the state, she's already been convicted in the past of selling drugs, possession of methamphetamine to sell drugs. And then, I'll tell you something else that's peculiar. There's syringes in the car. We don't even know if they were used, but if they were used, we could have sent them off and we could have found out who was using them. That would have been good evidence to have. No fingerprints. They didn't fingerprint the scales, drug baggies, nothing. The only person who knows what happened and how that drugs got here was the driver of the car. She testified. Come up here and had to take the fifth. She told you how those drugs got in the car. Mr. Lynn is not possessing drugs with intent to sale. Furthermore, if you recall from the video, the way I see it, and you're the final arbiter of the facts. But I think if you look at that video again, I could not determine that there was any scales in his lap. looked to me like he fell out of the truck somewhere. And he also stated that in 2 reports and to the K-9 officer. He didn't say, because what would have been really good evidence? Oh, Mr. Lynn's up there with a set of dangerous scales inside, but he didn't say any of that to the K-9 officer. Further, I mean, the officer wants to say, based on my training and experience, and that, hey, you're typical meth person or something. Well, Mr. Lynn is not your typical person. That's Loretta Lynn's grandson. We went through that when we picked jury. Did anybody know him? Did he know the family? He's not selling drugs. And I'm going to ask you to go back there. The only thing he's guilty of is he had some drugs in the shoe and find him guilty of simple possession. Thank you.
General McLeod, you have the right to close.
Thank you, Judge. So I would respond to the defense, telling you that there were no fingerprints tested, the syringes weren't tested. What Mr. Baker's trying to do is to create some sort of reasonable doubt in your mind to where you feel like you can't convict Mr. Lynn of these offenses. I would just ask you to recall that on the body camera footage that you've watched, Mr. Lynn took responsibility for everything that was found. He stated it was his. He even went so far as to say that Miss Garner had nothing to do with it. He did, at no point did he say, I didn't know about those drugs. I had no idea. I just got here for a ride. No idea where the stuff came from. He could have said that. He didn't. He said they were his. I say we should take Mr. Lynn at his word, regardless of who his grandmother is. He tells you those are his drugs. Those are his drugs. You heard Ms. Garner testify. It's the state's opinion that she is not a very credible witness, that she has a motive and incentive to come here and lie to you today in order to protect Mr. Lynn. She's clearly no longer in a relationship with Mr. Vetter. She doesn't care what happens to him. She testified that she herself is on probation. She's been convicted of being a drug dealer. Mr. Baker said something when he first started talking to you about the light, tail light in the vehicle, working or not working. As you may recall, Ms. Garner herself said that there was something wrong with the light. She said there was a short or something in it, which would corroborate that the officer likely observed a short or malfunction in the light, would go on and off and work one minute and not the next, which would be a justifiable reason for the stop. Having said all that, we'd like to briefly talk to you about the law in this case, which the judge will go over that with you, so I'm not going to spend a whole lot of time, just kind of summarize what the law says. The law says in TCA 3917-417, it is an offense for a defendant to knowingly manufacture a controlled substance.
I don't object. That's outside of the law. That should have been primary argument. I didn't read anything about the law whatsoever.
It is outside of the argument that Mr. Baker made, so I would sustain the objection.
Okay, Judge, that's fine. The judge will talk to you about the law related to this case and he'll go over that with you. Okay. I don't have anything further.
All right. You will hand this to the jurors.
I think we're gonna skip the jury instructions and go to the end, hopefully, and then we'll skip the verdict watch and have the verdict possibly.
All right, ladies and gentlemen, this will be the final charge of the court.
There you go.
The defendant, Jeremy Jacqueline, is charged in count 1 of the indictment with the crime.
Okay, so that's the jury instructions. We can skip that part and go to almost the final part of where he's talking.
Let us know. We'll have to bring you back in. Any questions, we'll bring you back into the jury room to do it. If you need to watch the video again, you'll have to come back in to do that. And if you have reached a verdict, you'll just let the bailiff know and we'll bring you back in and receive your verdict. You may now retire to begin your deliberations.
All right.
Right,
You guys,
these are the initial exhibits and the initial charge of the court. Court will stand in recess pending the return of the honorable jury.
all right. Are you guys ready for the quickest verdict that's on history? So I think they come back to watch the video first of all because it looks like so. Let's watch that first, and then we'll do the verdict. But the thing is, compared to the 20 hours that we spent on the KR verdict, I think this one we can handle. Jury is muted. The judge is muted, which is awesome to know that the judge is muted. There you go.
They say which one they want.
We're going to find that out when they come out.
I liked being able to skip the deliberations and all of that. It's great. Okay. Do you want to see the video? We're not gonna watch the video again, so let's skip to this part.
If we could find a section that we originally skipped, because I think there was 2 sections we cut out.
There was.
Okay. Judge is out, and he comes back around there, I think. Let's skip it. There you go. Hopefully you will unmute on time so we can see the verdict, because otherwise I would be very angry.
We've been notified the jury has reached a verdict.
Verdict is it?
Yes, the little type of lady in here. Yes, let me get Miss Payne to text her. The little type of lady. Court report.
Thank you. Well, as soon as the little typing lady comes back in, we'll...
I text her.
And we are waiting for the court report again.
I think that's appropriate for this entire case.
I would agree.
Oh, this case has been fun. It's been a good one. Good pick, I think. It has been fun. And fast as well. We're still waiting on the...
And I was interning with the DA's office when I was in law school in Houston, Texas, and I was interning with the DA's office. We had a case where these 2 gentlemen were charged with bank robbery, and I was helping this guy try the case, and it was an open shut case. They had a video in the store of them robbing it. They had been caught like a block or 2 away with the money and the guns that they used, but apparently they weren't offered anything, so they just thought, well, why not? So they went to trial, and it was finished like by 1 o'clock in the afternoon, and the jury began deliberating. They just went on and on and on and on, and nobody could figure out what in the world was taking them so long to determine. Finally, at 5:05, they knocked on the door, came back out and found them guilty of all the charges, like everybody expected. So someone asked the jury foreman what was the problem. Why did it hang him up? So, oh, we found him guilty right off the bat, but we thought we had to work till 5 o'clock.
That's great. I can just over here in a minute. There she is.
Welcome back, Ms. Pam.
Yes.
All right, we were ready. You ready, Pam?
I am.
All right, bring the jury in. That you have been able to reach a verdict, is that correct? All right, well, the foreman, do we have everybody here? If you are the foreman, if you would please stand, and I'm just going to go along this verdict form with you. As to count 1 in the indictment and the charge of possession of heroin with intent to sell or deliver, how does the jury find the defendant? Not guilty or guilty?
Guilty.
Guilty of count 1. As to count 2, possession of methamphetamine with intent to sell or deliver, how does the jury find the defendant? Guilty or not guilty?
Guilty.
As to simple possession in count 3, how does the jury find guilty or not guilty?
Guilty.
All right. Ladies and gentlemen, if you would, thank you. If that would signify that this is a unanimous verdict by the raising of your hands, this will demonstrate that it is unanimous. All right. Thank you. Let the record reflect it is a unanimous verdict on all 3 counts. Thank you. If you'll turn that original verdict form into our bailiff, then as you're leaving. Ladies and gentlemen, that concludes your service. We're appreciative of the fact that this has been an all-day thing for you, and there's been some hiccups along the way. I want to thank you for your patience and your cooperation in trying to get this thing done. You are not required to talk to any of the lawyers. If any of you want to talk to the lawyers to get their perspective, you're welcome to do that. Other than that, you are free to go. And I wish I could tell you that we won't need you again, but there is that possibility that we'll have a trial on the 25th. So if you'll check that number on the 24th after 5 o'clock, we'll let you know for sure if we need you. Okay. Thank you very much. You are free to go. If you want to keep those charges, all I need is the original charge from the morning and the original charge this afternoon and the verdict form. If you can keep your copy, juror copies, you can keep them or throw them however you want.
If y'all leave your little jury tags in the jury room, and if you need a work note, give me just a few minutes to get downstairs and I'll get you one. Thank you.
Thank you. All right, ladies and gentlemen, we are now need to set a sentencing hearing. And my next term would be October here in Humphreys County, but we're required to do that. We're supposed to do that within 45 days. Is there any objection to waiving of that 45 days, Mr. Baker? If not, we can do a sentencing hearing out of the county if you're in agreement.
Whatever, Mr. Baker.
Mr. Lynn said October's fine.
He is in custody now, correct?
Yes, sir.
Then we will set the sentencing hearing for 1:30 on October the 7th. Well, we have not any idea how long, we don't know anything about it. Let's set it for 1:30 on the 7th. If that looks like it's going to be a bad day, we'll pick another one. But
And Judge, Mr. Lynn does have 2 other cases pending. Do you want to just put those on to be set at that
put them
time?
on the 7th of October to be set.
Yes, sir.
Right. That concludes our business, and Mr. Lynn is remanded to the custody of the Sheriff's Department pending a sentencing hearing on the 7th day of October at 1:30.
Oh, Ross, I must go down and get my jewelry out of here, and I'll be back.
Make sure that they get.
And he got found not guilty. I know, that's what I was just gonna say. He has more cases pending, and this is the great use of the taxpayers' money of putting. I know everyone has the right of fair trial and everything, but it's just crazy. But that was funny. I like that. I think I'm gonna name this one as the spicy and the funniest trial ever, because I like that story that that you was just saying while we were skipping, which it was rather funny. I like that. But it was nice. It was a nice easy trial to follow, very simple, very spicy, very funny. But right now, I to end the day, I want to show something that has happened. So in a Kansas courtroom, erupted into literally chaos as the grieving families traded punches during the sentencing of a teen convicted of unaliving a 14-year-old boy. So this is scenes from the courtroom. It starts like straight away. So let me put that on. Hang on 1 second. Let me do that. Do this and now play. Just hang on.
A Kansas courtroom erupted into pandemonium as grieving families traded punches during the sentencing. Now, moments after her emotional statement, that's when tensions erupted. You can see deputies stepping in to escort people from the gallery as shouting breaks out, and then the first punch is thrown. Now, actually, let's take a closer look at how the chaos unfolded. So in seconds, the courtroom descended into violence. Officers rushed to break up the fight. Multiple family members from both sides got involved. One woman can be seen lifting a baby from a stroller, get the baby to safety as this chaos spills across the room. Even the victim's mother, Jeanette Dees, who I mentioned before, was allegedly seen physically engaging in the scuffle and even maybe allegedly spitting at the attorneys. Now, at one point, a sheriff's deputy can be seen asking a woman, "Is your baby okay?" Again, a haunting reminder of how far this chaos had spread. So what on earth led to such an explosive scene?
Wow, that was just like literally. I can put the rest of this video, but it's online crime sidebar. It's one of their latest videos, but I thought it was just interesting to show that like the craziness that happened in the trial. It's a very sad case, indeed, but yeah, it's not to so worth a watch in the background. And I think that's going to be it for today. I mean, we have done a good few hours. I have a trial. It was good. We got to hang out for a bit, but it is Friday. And for those that can, we'll enjoy our weekend. But I'm gonna wish you all a good evening, afternoon, and a great weekend. I'm gonna try to get out a members video for this weekend for this time. But I have a great time, a great weekend. We'll be back on Monday for our trial for the Connecticut trial that we've been following. And I'll see you all then. Have a great one. Have a good afternoon, evening, morning, wherever you are. I'll see you all. Bye.
and I'm a real-time crime professional.